We're waiting right now for Chris Nicola to tell us that we are all set and ready to go in terms of all the people being present, as well as all our technical questions resolved and Zoom up and ready to go. So as soon as Chris tells us we're good to go, we'll start.
Mr. Chairman, I think I have everybody here. I don't see Jennifer Boston Alvarez, though, if she's here.
I didn't either, Chris. This is Bridget. And Mr. Delory, is he here?
Yes, I saw him.
Okay, because I don't see him.
I'm up in the top corner, the bald guy that with the.
The screen is, oh, okay. It says Matthew Summit.
Yes. I had my last name changed to the city I work for.
That commitment.
Yes, dedication, right? Thank you.
Dedication.
I appreciate
Well
that.
done.
And is Miss Bolson Alvarez on here? I don't see her either. Okay. And I have all our other members present. Okay.
All right. All right, so we can get underway. Chris, is that right?
Yes, if you'd like to open it up, you can.
All right, well, let's call this meeting of the Summit Planning Board to order. I'll read the adequate notice statement. Adequate notice of this meeting has been provided by the board in preparation of the 2020 annual meeting notice, which sets forth the date, time, and place of this meeting, and by properly posting such notice and forwarding the notice to those designated newspapers and persons requesting meeting notices. Moreover, in order to comply with the national and state declarations of emergency related to the COVID-19 pandemic, and in accordance with the municipal land use law, the Open Public Meetings Act, and the recent operational documents from the Department of Community Affairs, this meeting is being held virtually as a web-based platform with remote public access. And let's go to our Pledge of Allegiance. If you, all people looking behind me, you'll see the back of the Summit City Hall, and right over my right shoulder or the left side of your screen is the American flag. I pledge allegiance to the flag of the United States of America and to the republic for
which it stands,
one nation, under God,
indivisible,
liberty
and justice for all.
Thank you all. That was very well done. Mr. Nicola, can you go through a roll call for the board members?
Certainly, Mr. Chairman. Chairman Anderson,
Present.
Vice Chairman Brinkerhoff,
Present.
Councilmember Little,
Present.
Ms. Boston Alvarez. We are Mr. Drummond.
Here.
Ms. McNeil,
Here.
Mr. Delory,
Here.
Mr. Zucker,
Here.
Laura,
Here.
Mr. Fiore,
Can't hear you, Chris.
Mr. Fiore,
Here.
and Mr. Formicelli.
Here.
And for the record, Mr. Warner is here. He's our board attorney. You have a quorum, you can proceed.
Mr. Chairman, you may be on mute.
Yes, I am. I was just going to say Bridget has a challenge tonight, trying to keep us all in line. So we all need to speak one at a time and clearly, and I will help direct that as we go through this, as well as Chris Nicola will. Let's go to item number 5 in our agenda, the meeting minutes. Any of the board members have any comments to the meeting minutes? during the course of the meeting, I will read each of the board members' name and ask for comments. But I think with the meeting minutes, we don't have to quite be that formal. If anyone has any comments with regard, I have some if no one else does. Okay, so if we go to the last page, the fourth paragraph down that begins Ms. Balson Alvarez. We're talking about the ORC zone here. And in both cases, as it relates to ORC and Gateway 2, the comment in the meeting minutes says the required, the full board one-time permits. So I guess, Mr. Nicole, you're just trying to kind of a shorthand there to say when the board meets or when the board has time, they'll deal with these two more complicated or more detailed issues.
Yes, that's correct. I can certainly reflect that from what you just said.
If anyone else on the board is okay with that, if everyone else is okay, we can leave it as is. I've just wanted to be sure that people understood kind of what that meant. With regard to the last paragraph, I'd like to add a sentence at the very end, basically confirming that or proposing that a meeting will be set for, or will be held August 20th, 2020. Just to make note of that, Mr. Nicola, that we in fact did propose a specific meeting for the special meeting, or specific time and date for a special meeting. And those are my only comments relative to the meeting minutes. Does anyone else have anything at all? Okay, all right, thanks, Mr. Nicola. We have item 6 on the agenda is public hearing.
Chairman, you need a motion to approve.
Oh,
this.
sorry, yeah, I apologize. We need a motion to approve the minutes and a second, please.
So moved.
As amended?
And a second from someone. I'll take off mute.
Second.
Okay, Mr. Perrella. Thank you, Andy.
All in favor?
Aye.
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 See you.
Chairman, I abstained. Greg Drummond wasn't there for the meeting.
Yes, thank you, Mr. Drummond. Item 6, public hearing, Cardone Contracting, Inc. will be carried. The applicant has requested that it be carried to the next meeting. We have scheduled that meeting for September 23rd. And as I understand it, Mr. Warner, that it will be carried without further notice at this time.
Actually, Mr. Chairman, it's my understanding, and Chris, please correct me if I'm wrong, that the applicant has recognized that they have to carry that with
Okay,
further
good.
notice.
All right.
I would also, Mr. Chairman, I know you mentioned a new date. Do you wish to speak to that September 23rd date as opposed to the originally scheduled September 28th date for the benefit of the
Yeah,
members
I
of the
think
board and the public?
in the case of item 6 and item 7, rather than extending these to September 28th, which is a religious holiday, we have decided as a board to move that meeting to September 23rd, which is a Wednesday, so that we have no conflict with either applicants' attorneys or any board members.
And if I may, Mr. Chairman, just to clarify with your permission procedurally, while the effect may be the same, moving one meeting to from one day to the other, technically we are not doing that because we annually noticed the September 28th meeting. My understanding is that we will be scheduling a special meeting for September 23rd. And in doing so, we will be carrying both 83 Maple, and not to get too far ahead of the board, my apologies, Mr. Chairman, but the next one as well, 43 Woodland Avenue, to this newly scheduled special meeting on September 23rd. And it may be, Mr. Chairman, don't mean to put words in anyone's mouth, that will be canceling the September 28th meeting, which was the originally scheduled meeting.
That makes sense. Thanks, Mr. Warner. That's right. And with regard to item B under the public hearing, number 6, Beechwood at Summit LLC wants to be carried as well to that, or will be to the September 23rd date. And I have a note here that says without further notice on this one. Is that correct, Chris?
You know, it is, Mr. Chairman, but if I may, on that one as well, since we are scheduling a special meeting,
Yeah.
It would be my advice to the board, and Chris, perhaps you can very quickly notify council for that applicant that since we are carrying to a newly scheduled special meeting that will be scheduled first thing tomorrow, that they do that with notice, with further notice, to ensure there's no problems with giving full and fair opportunity to all members of the public to participate.
Okay, very good. Thanks. All right. So we come to item C under item 6 there, the Primrose School Franchising Company. Mr. Warner, I suspect you would like to address the applicant's counsel at this point.
Chairman, if I may,
Oh, yes, yeah, Mr. Drummond.
Greg Drummond, I request that I recuse myself from this application. I have insured both titles to both buildings, and I have a strong business relationship with the landlords and tenants in both buildings.
Thank you, Mr. Drummond. I appreciate it.
Thank you.
All right, Mr. Warner?
Certainly, and I know we still have 9 members, a full complement of the board to proceed with the application this evening. Perhaps it's best if applicant's counsel enters his appearance first, and then I can address some predicate issues with everyone.
Sure. Good evening, Chairman Anderson, members of the board, Craig Genetti of the law firm Dave Pitney on behalf of Primrose Schools Franchising Company.
Okay. And Mr. Chairman.
Mr. Giannetti, good evening.
Thank you. Good evening.
And if I may, Mr. Chairman, a couple of predicate issues. First, the first predicate issue we always confirm is the notice that was provided, which gives us jurisdiction to hear and decide an application. I did have an opportunity to review the notice that was both published and personally served. I found the content to be sufficient under the municipal land use law and the guidance we have under the Pearlmark case and its progeny. I also understand that it was timely served, both certified mail, August 13th, published August 14th, both 10 or more days prior, at least 10 days, excuse me, prior to this evening. Under the municipal land use law, that's timely service and the content being sufficient. It would be my legal opinion that the board has the jurisdiction by way of the sufficient note and timely notice to hear and hear the application this evening. And if we were to finish the application this evening, then to decide the application. The other issue I would like to address, predicate issue, is, well, a couple. One, it's my understanding there were some written communications that may have been sent to one or more board members from members of the public. Those were not considered by anyone because, as I advised the board members, and as I believe the board members knew anyway, and was communicated to individuals who made such submissions, we cannot receive documents from members of the public or anyone for that matter unless there are witnesses who have personal knowledge of the information contained in those documents, who testify under oath with respect to those documents and introduce those documents. So members of the public, when we get to that point in time where there's public comment, you can read what you wished to submit to the board. You can testify essentially in any way, shape, or form relevant to the case that you wish to do. You could do both and introduce documents, but you cannot submit. No board member is allowed to consider, because board members are like judges, quasi-judicial representatives in this quasi-judicial body. They cannot hear and consider evidence outside of the properly noticed public hearing during this properly noticed open public meeting. So I hope everyone understands that. It's just the rules of the game, if you will, under the municipal land use law. It's so everybody has a full and fair opportunity to appear, be heard, and to be able to cross-examine individuals who raise issues, as opposed to simply cross-examine a piece of paper that's considered outside of a hearing. That just wouldn't be possible.
Mr. Warner, and have you seen those emails from the members of the public to the board members?
I did see one email.
I was just asking maybe at some point if you could forward me a copy of those emails.
It's a fair request, Mr. Chairman, in my opinion.
Sure.
And I'll defer to the board, but I have no objection to that request.
I think it's fine. Yep.
Okay. The other thing I wanted to mention, it's my understanding that members of the public, well, first of all, let me ask, is there any attorneys representing any members of the public, representing anyone, other than obviously Mr. Giannetti has entered his appearance representing the applicant? Are there any attorneys, currently represented by an attorney, neighbors, objectors, members of the public, anyone? And I get asked, Chris, maybe you can, does everyone know how to indicate, raise their hand, indicate, speak up, what have you, to make themselves heard when a question like that is asked?
Yeah, you could either use the reaction, or you could type in the chat, or you can use the more button in your participants feed to raise a hand as well.
Okay. And I take it you're not, and also can people telephone in to you, Chris?
Yes, I would say due to the vacuuming, I'm now in the other room, so the email is definitely the best way, but I can make my way back to my desk if we need to.
Okay. And I'm going to ask with respect, I did just see a chat thing post. I'm going to respectfully ask that we not have any further chat messages. That's, in my opinion, not the most appropriate way to go about, because that could interrupt the hearing. But it is my understanding, and I was going to get to this, I wanted to see if there were any attorneys yet representing anyone. It was my understanding that there may not be, and it appears as if there is not. But it's also my understanding that there are members of the public who are interested in retaining counsel and or experts, and have asked, they've communicated through a potential counsel, if you will, perhaps, that they were going to ask for an adjournment this evening, rather than have multiple individuals request an adjournment. It's my understanding that request is going to be made. And what I would do, my advice to the chair would be that Mr. Giannetti address that request, whether or not the applicant wishes to consent to carry this matter to the next meeting, which may be, I believe, the special meeting that is being scheduled for September 23, or not. Because given that the notice was sufficient, it's at this point, in my opinion, discretionary, at least initially, from the perspective of the applicant.
Thank you, Mr. Warner. And I did become aware this afternoon that there potentially could be this request to retain counsel and seek an adjournment. And I guess so it's clear for the record, there appears to, and whether or not, if it's okay for me, Mr. Warner, to address the comment in the chat, but it looks like there's an individual, Alexander Rodriguez, who indicated some neighbors will consider an attorney. As of now, we have not retained the service. From our standpoint, there was adequate notice and ample time for anyone that wanted to consult with either an attorney or any other expert, engineering or otherwise. Obviously from my client's standpoint, they have obligations under certain contracts and leases with respect to the property to diligently pursue all approvals, as well as timeframes in which they have to obtain those. And we feel being able to proceed tonight, we can present our application. It's not even clear if the residents will obtain an attorney. They appear to be on, as I see there's over 75 participants. They'll have ample opportunity to be heard. And then as we progress, I would at least like to start and begin the hearing, and then we can address towards the end. Obviously, if there's comments from the board where we need to make plan revisions, that will give the residents opportunity to engage counsel between now and then, as well as view and or listen to this hearing and get up to speed. So I don't think a straight adjournment at this point would make much sense, since we have an opportunity to proceed and the residents do have an opportunity to be heard. So I'd rather present our application and then allow the public to participate. And then if we're at the point where it comes to a vote, I think you, myself, and the chairman and the board can address whether it'd be appropriate to call for a vote or adjourn it. Or if there's at least we're getting initial feedback from the board and we have to come back anyway, at least we'd have time to address some comments of the board between now and the next meeting.
And Mr. Chairman, it's really a discretionary call on behalf of the chair and the board. Certainly the applicant, given that the notice, in my opinion, is sufficient and timely, has the right to proceed. But it's ultimately the board's determination. If I may, for a moment, I did note a couple of chat notices, and again, I think we should limit, if not eliminate, the chat function. Shouldn't really be a part of this, but let me. There seems to be some question as to what the notice is, and just for the record, if I may, and Mr. Genetti can feel free to weigh in as well, with your permission, Mr. Chairman. The way notice works under the municipal land use law is at least 10 days in advance of the night of the hearing. It must be published in a newspaper in general circulation, the official newspaper in the municipality, which it was. We have an affidavit of such publication, as well as sent by certified mail to all owners within 200 feet of, who own a lot or have a lot within 200 feet of the perimeter of the subject lot, or in this case, I think we have lots 1 and 2, 2 lots. So anyone whose lot touches within any portion within 200 feet of the perimeter, I'm making the perimeter icon on with my hand here, of the subject 2 lots, you would get that notice. It is complete, service is complete upon mailing. And I know that the U.S. Post Office, well, I'll leave it to everybody to make their own determinations currently as to where the U.S. Post Office stands. But it is complete upon mailing, and we have the affidavit and proof that it was mailed to those individuals whose properties are located at least somewhat within 200 feet of the perimeter of the 2 subject lots. It was sent at least 10 days in advance by certified mail. We have that proof. Would that be an accurate encapsulation, Mr. Giannetti, of the notice requirement?
Yes, Mr. Warner.
Okay, so that's how that works. So all back to you, Mr. Chairman. I'll throw in one other thing, though. I do note we have other items on the agenda that, as a board, we do have to hear tonight. So I suspect we're not going to have a full evening for this case, even if we do proceed this evening. But I'll turn it back to the chair.
And Mr. Chairman, if I may, it's Matt Delory. Jennifer Bolson Alvarez is present. I did notice just
Oh.
to make sure that she's represented here.
Okay, great. Thanks.
Yep.
Okay, board member Bolson Alvarez, were you present when we started this hearing moments ago?
Oh, yeah.
Okay,
I
so
only
she's
missed
heard the
first 6
entirety.
minutes, 7 minutes.
Okay, and Mr. Giannetti, you have no objection to her participating if we're going to proceed this evening?
No objection.
Okay, thank you. Thank you, Mr. Chairman.
So thanks, Mr. Warner. Mr. Giannetti, we'd like to proceed forward. And as Mr. Warner said, we do have other business. So we'd like to see if, I don't know how long it'll take you, but around 9 o'clock or so, we're an hour and a half or an hour, 9:30 at the latest. We'd like to see if we can kind of wrap that up and move on to other items as it relates to that the board has. We're working on a DRO update, which is been a very time-consuming document. So if that's possible, we'd love to have you, begin and take it from here.
Mr. Chairman, if I may make one inquiry, is it the board's, in light of the fact that we're probably going to have an hour and a half roughly of testimony, is it fair to say that that this matter is not going to be completed this evening, and members of the public will have an opportunity in the interim between now and any adjourned date to retain counsel, retain experts, hear the recordation of this meeting, and have an opportunity at that point in time, including their opportunity to question witnesses this evening, but at that point in time to present witnesses and have them heard, should they so desire.
That's the intent. And assuming Mr. Giannetti is okay with that, I think that's the intent. He kind of said so much in part of his presentation anyway, as it relates to at least getting some of the issues out that the board has some concern on, so that his team can study them, as well as neighbors can, objectors can get together with council based on that.
Mr. Giannetti, you'll stipulate that the matter will not conclude this evening and that members of the public will have an opportunity to retain counsel and experts should they so desire in the interim between now and the next meeting.
Yeah, I mean, I don't know if it's something to stipulate, but I recognize that given the time constraints, the number of witnesses we have, as well as the number of members of the public, that it's not realistic that we're going to finish this evening.
I think that's fair enough. Mr. Chairman, back to you.
Thank you, Mr. Giannetti. Why don't you proceed with your team? We look forward to
Great.
hearing.
Thank you, Mr.
Hi,
Chairman.
excuse me 1 second. This is the court reporter. How is everybody?
Oh, this is the court reporter, Bridget Lombardozzi. I'm the board court reporter.
Oh my goodness. Well, I was the court reporter. That was hard. I've been taking the whole thing down also, but since you are the board's court reporter, you are the official record.
Chris?
Mr. Giannetti, did you?
Yes, we
did
hired
you
and brought
retain
our
your
own. Yes, we did retain our own court reporter.
Oh,
Good thing I said something.
Okay.
Okay,
All right.
so I guess then I will log out of the meeting if that's okay with everybody.
So, Mr.
Unless, Mr. Chairman, this is Bridget. If they want their own court reporter for this particular matter, that's up to them, but it's actually up to you.
Mr. Giannetti, what's your call? If you wish to have your own court reporter, that seems to be fine. I guess the question is, which is the correct record? I assume Bridget,
Yeah, I think it's fine to, use the board's court reporter and rely on that as the official transcript.
Okay, that's no problem. I believe that is the proper protocol as well. Whenever I've run into this before, we always are supposed to defer to the board reporter.
Okay.
All right, well, everyone have a great meeting then.
Thank you.
Thank you,
Thank
Allison.
you.
Before we proceed, did you officially want the chat disabled? I just wanted to be clear.
Yeah, I think we should have the chat disabled, and frankly, that'd be my recommendation going forward. It's my recommendation to all boards. It appears to, as long as there are multiple alternative mechanisms for individuals to be able to speak when they wish to do so, which there is, it's a more, the meetings run better that way, and it's legally.
When it's time for public comment questions, Mr. Nicole will repeat how to make comments and how to get in touch with us.
Okay.
Yep. Okay. All right, so we'll disable that function for now. And Mr. Giannetti, we really mean it this time. It's time for you to begin.
Thank you. And given the time constraints, I'll try and keep my intro brief. Again, Craig Giannetti, the law firm Day Pitney, on behalf of the applicant Primrose School Franchising Company. This is an application for preliminary and final major site plan approval with variance relief for property located at 480-490 Morris Avenue, block 505, lots 1-2 as identified on the town's official tax map, and in the B business zone. The property currently has about 1.09 acres and contains 2 existing buildings. We are seeking site plan approval to demolish the existing building on lot 1 and construct an approximately 8,860 square foot addition to the existing building on lot 2, resulting in one building, approximately 21,072 square feet on the property. And we're proposing to utilize that and operate a Primrose daycare school on the property where child care center use is permitted in this zone. There's also approximately 6,102 square feet of space on the second floor that will remain office space, and approximately half of that will keep the existing office tenant there. The other half of the office space will be utilized by the Primrose School for its back office or administrative operations or things of that sort. There's also a playground proposed as well as associated parking. The applicant is proposing to provide 40 parking spaces in addition to additional landscaping, signage, and other site improvements. In addition, as part of the application, we're going to be proposing to merge both lots 1 and 2, so it's a single lot with a single building. As part of the application, there's a series of variances we are seeking, and I'll have the professionals go into greater detail as to what those are and what we're seeking and the justifications for them, as well as a couple design waivers as well. For this evening, I have 4 witnesses to present, or at least for this application, we'll have 4 witnesses. We'll see how far we go. The first one is Josh Klein, a civil engineer with Stonefield Engineering. We also have James Cassay, a licensed professional architect, Matt Taylor, who is a representative of Primrose, and then Matthew Seckler, who is a traffic engineer and licensed professional planning. So he'll be testifying as to both subjects, and when the time comes, we'll qualify him in each of those areas. With respect, I guess, to a housekeeping matter, and I've been on several of these Zoom board hearings, and some are handled differently, but given the procedure of normally after each witness opening it up to the public and going through that process multiple times for each witness with so many people on a Zoom, what I have requested before and what the board or some boards have been okay with is asking if we could present all of our witnesses, and the board is free to ask our witnesses questions as they go, but when it comes time for the public questioning, they would come at the end and they could ask any one of our witnesses questions rather than opening up after each witness, just from, I think, an efficient procedural standpoint, as well as I'm sure there'll be a number of questions as to operations and things like that, which some of our first witnesses, our civil engineer and architect, can address, but we also have a Primrose representative. So, to avoid opening up to the public and asking the engineer, operational question as to the school. So I'll just make that request.
Mr. Chairman, I can advise the board on that request if you'd like me to do so.
Please do, yes.
My advice to the board is that notwithstanding the potential efficiencies of doing so, that it would be more appropriate for everyone, including members of the public, to have the opportunity to contemporaneously question each witness immediately after their testimony is provided. So that is, as I said, contemporaneous as opposed to belated, many witnesses later, and perhaps a month or 2 later.
I concur with that. I know it'll be longer, Mr. Giannetti, but I think it's fair to the public that they have a chance to question each of your witnesses. And I know it'll be a little bit slower, but we appreciate your patience.
Sure. So then at this point, I'd like to call, I guess, also procedurally, to my understanding, Mr. Warner, is as we're presenting exhibits, those exhibits are online on the planning board's website. And as we go through our testimony, our witnesses will share, when they want to use an exhibit, will share that exhibit on their screen. And I'll warn you ahead of time, Mr. Warner, I guess we're going to have to mark them our own A1, A2 as we go, because just from the timing and when we had to get it uploaded or sent to the planning board so they can upload it up to the website, they're not necessarily pre-marked in a particular order. There's markings on the exhibits and we can reference them, but on our own, we should be keeping the A1, A2, A3 list.
And that's fine. It's my understanding as well, Mr. Nicola could correct me if I'm wrong, that the exhibits were put up on the screen at least 48 hours in advance, correct, Mr. Nicola?
Yes, that's correct. There were 3 exhibits submitted.
Okay, and they should be sequential. So as you introduce them, you should have them A1, A2, A3, and that's fine. That's the way it should go. Also, I'm happy, Mr. Chairman, with your permission to swear in all the witnesses at once, including our board professionals, our engineer and our planner, if that's acceptable, so we can get that done at this point in time.
That makes good sense. Thanks.
And I would ask Mr. Giannetti if you can have all 4 of your witnesses raise their right hand And if our
Yes.
planners and engineer can do the same.
That'll be Josh Klein, Jim Cassay, Matt Taylor, and Matthew Seckler, which I see 2, 3. Yep, they're all up.
Okay, and we
I
have
will
our.
need the spellings of all their names.
Sure, it's Josh Klein, Josh space Kline, James Cassay, also Jim, Kassa, Matthew Taylor, Taylor, and then Matthew Seckler, Seckler.
Thank
We
you.
also.
There's a Y on that. There's a Y on the end of my name, Kassay.
I'm sorry, I thought I said that.
No.
Okay.
And we have our planner, Joseph Burgess, and I don't know if we have Mr. Behrens as well, Joe?
I don't know, he's coming back for the DRO. discussion.
Later, okay. And do we have our engineer?
Yes, Chris Dewar.
Oh, there, I'm sorry, Chris.
There you
Chris
are.
Dewar is our engineer, who you probably have both those names already. And now, hopefully all of you were able to keep your hands raised that long, but if not, put them back up again, please. Do all of you swear to God or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
I do.
I do.
I do.
Okay, thank you. Everyone's been sworn in, Mr. Chairman. I suspect Mr. Giannetti could start with his first witness, Mr. Klein.
Okay, thank you.
Thank you. At this point, I'd like to call Josh Klein. Let me see if I can find him. Mr.
Good evening.
Yes, thank you, Josh. So Mr. Klein, if you could please just provide to the board, I would guess your name and address just for the record.
Yes, Josh Klein, last name Kline. I work for Stonefield Engineering and Design, located at 92 Park Avenue, Rutherford, New Jersey, 07070. I'm a licensed professional engineer in the state of New Jersey as well, and my license is in good standing.
And with that, you just some of your experience in the field of civil engineering and qualifications and other boards you've been accepted before as an expert.
Of course. I attended the University of Vermont, where I received a Bachelor of Science in Civil Engineering. I have over 7 years of experience in land development, specifically site engineering. I've worked on over 150 projects, including commercial, residential, and industrial projects throughout the Northeast, and I have been qualified as a licensed civil engineer by multiple land use boards in the state of New Jersey.
At this point, I'd ask that Mr. Klein be accepted as an expert in the field of civil engineering.
Any board members have any objection to that?
Nope.
All right, Mr. Klein, you are accepted. Yep.
Great. And Mr. Klein, you and your office, Stonefield Engineering, were engaged by Primrose Schools as the civil project engineer for this project.
Yes, that is correct.
And as well, we're going to be using some exhibits this evening. And were those exhibits prepared by you or someone under your direction?
Yes, they were.
And maybe what we can do is just mark those now for identification purposes. I don't know if you have them up and have the ability to share them. I guess the first one being an aerial photograph.
Yes, the first exhibit I'll mark as A1 is an aerial exhibit, again, prepared by our office, dated 8/12/2020. And that is up on the screen. Can everyone see my screen?
Yes. And then in addition, was there a color rendering of the site plan? If we can mark that as A2. And this is essentially a color rendering of the site plan that was part of the plan set that was submitted as part of this application.
Correct. It's the same site plan that was part of the application. We've just kind of colorized to help explain throughout the presentation.
Sure.
Mr. Giannetti, if I may, just for further specification, would that have been sheet C4, the site plan sheet from it looks like
Correct.
July 7th, perhaps, 2020 last revised, that's been colorized?
Yes, that looks like sheet, yes, C4 of the plan set.
Okay, thank you.
So maybe I guess, Mr. Klein, if you can just give a kind of brief introduction as to, this site and this application.
Oh, perfect. Thank you. Thank you for having us tonight. Just to kind of start things off, I think, we have a great application in front of us tonight. It's an adaptive reuse where we have a redevelopment here of a site that at the end of the day is a little bit tired and dated. So this application is really going to be looking to kind of bring it up to standards and going to overall be a really positive application for the community. So kind of the first step in any of these applications is really the site selection process. So, Primrose, the applicant, they operate, hundreds of these child care centers across the country, and they've
Excuse me, this is the court reporter. Can we please mute everybody else?
Mhm.
Thank
Chris,
you.
can you mute everyone?
I think Mr. Warner is still muted. We all set? Thank you, Mr. Warner. So I'd kind of just continue on the idea of site selection. So I think a good intro to this application is this kind of point that this applicant operates hundreds of these child care centers, and they've kind of specifically looked at this center, looked at the operations, looked at the parking, looked at the surrounding traffic, and they feel this application and this proposal is more than adequate and would be a great location for this type of use. And again, it is a permitted use, a child care center, as well as the office. So I think the first thing when you think about child care centers, and something I like to kind of talk through with the board is, in no way is Primrose Schools or Primrose Child Care Center a school. This doesn't operate like a school. This doesn't in no way, shape, or form is a school. So, schools experience strong spikes in demand. Almost 85 to 90% of traffic is in and out during a 15 to 30 minute window. So if you think about it, there's this surge effect or bell, and there's no surge effect with Primrose School. I mean, everything is kind of spread out through the course of a window, and there's no bell. So from an operations standpoint, a traffic and parking standpoint, there'll be other experts that will go on, after me and kind of go into more detail. But I do think it's something to kind of early on in the process to kind of get across that, that this is not a school. It's not going to operate in any way, shape, or form like a school. Great. So right now, what I'd like to do is turn to the aerial exhibit and just kind of get everyone oriented. So we have north at the top of the page, south at the bottom, and then we have west on the left-hand side, and we have east on the right-hand side. And I'll kind of be using that interchangeably kind of throughout. So as you can see, our site is located on the southern side of Morris Avenue between Webster Avenue and Gates Avenue. It consists of 2 lots within Block 505. We have lot 1 and 2. And just for everyone's reference, we have about 225 feet of frontage along Morris Avenue, 35 feet of frontage along Gates Avenue, and 100 feet of frontage along Webster Avenue. Just to kind of help orient everyone. So we have the Volkswagen car dealership to the north. We have some single family residents kind of to the south. To the west, we have a repair facility. And then to the east, there's, adjacent, I guess, abutting the property to the east, not across Gates Avenue. We do have an existing office building. We are located in the business zone, Zone B. Daycare facilities, as I mentioned, and office uses are permitted as of right. And just for everyone's reference, the site does border R5 and R6, and it should be noted that this kind of condition continues along Morris Avenue in both directions. There is a B zone that's along Morris Avenue, and then directly behind us there is a residential zone. So we're not the only property under this condition. So right now, and kind of to help talk throughout, we have lot 1 is going to be the corner lot between Webster Avenue and Morris Avenue, and then lot 2 it's not directly at the corner of Gates and Morris. It's kind of one property removed, but that's kind of the 2-story building is on lot 2. So we have a kind of a 2-story office building on lot 2, and we have a 1-story office building on lot 1. And just kind of identifying access, again, access there today isn't really signed or striped. There is some striping at the Gates Avenue entrance, but for the most part, it's not really signed that well or identified that well in real life. But there are kind of 2 unrestricted driveways along Webster Avenue. There's an ingress only driveway along Morris Avenue, and then there's an egress only driveway along Gates Avenue. And just under today's condition, lot 1 and lot 2, there's no access agreement or connection between the 2 properties. Some important site features to note from a site civil standpoint. The first item I want to talk about, which kind of really has impacted a lot of the design elements, is topography. So today, from the Gates Avenue entrance to the Webster Avenue frontage, there's about a 10-foot grade change across the site. And there additionally, to kind of help with that grade change, there is, as it exists today, about a 75-foot long, 2 to 3 foot high concrete retaining wall in between the two properties. And to kind of further identify this grade change for reference, the existing finished floor of the one-story building at the corner is at 271.7, and the finished floor of the two-story office building on lot 2 is at 278.7. So for reference, there's a kind of a 7-foot grade change between the two finished floor elevations of these two buildings that are, roughly 10 to 15 feet apart. From a stormwater management perspective, lot 1, there's no conveyance today. There's no stormwater system today. The majority of the parking area sheet flows directly to Webster Avenue. The roof is collected, and based on, some available mapping, we do believe it connects to the conveyance system with Morris Avenue. In terms of lot 2, the two-story building, there is a single inlet in the back of the site. There also is a trench drain within the ingress driveway on Morris Avenue. It is undersized, and when our team was out there, it was in kind of poor condition, so it's likely that it really doesn't provide much benefit. Our guess is water, for the most part, drains to Morris Avenue, but ultimately the drainage pattern and kind of based on the topography, the site does drain to Morris Avenue and is either kind of collected via a series of existing inlets within Morris Avenue or is directly connected to Morris Avenue. In terms of lighting, just something I wanted to highlight, that there is lights out there today. There are area lights. There are 4 area lights along the residential property line. So this is kind of the southern property line or the rear property line, kind of behind the buildings or opposite of Morris Avenue. So there are existing lights there. The lights out there today, they're not dark side compliant. They consist of either tilted flood lamps or tilted box fixtures kind of along this residential property. And they're mounted approximately like 18 to 20 feet high. So I'd like to move on to Exhibit A2 and kind of talk about the proposed site and some of the proposed changes of the project now that we've kind of highlighted the existing conditions. So, as noted in the introduction here, we do have a proposed child care center, Primrose Schools, that's going to be occupying the first floor at approximately 14,970 square feet. And then on the second floor, we do have a office use, which will be 6,102 square feet. The gross floor area of the building is approximately 21,072 square feet. There will be an architect testifying tonight, so I'll just kind of highlight some of the architectural improvements or some of the architectural changes just to kind of help the board in describing kind of what's happening. So again, we are doing an adaptive reuse of the existing 2-story building on lot 2, and we will be doing a first floor building addition that extends through lot 1. So kind of one difference because this is going to be one site now, we are going to be kind of connecting the two buildings. And as part of that connection, in order to kind of provide a consistent floor plate and provide, a cohesive connection between the two structures, we are proposing that they be located at the same finished floor elevation. So the 1-story building and the 2-story building will be built at the same elevation. And just for reference, kind of the main entrance, which today the main entrance for the 2-story office building is in the rear, that will remain, and the main entrance for the Primrose School will be in the rear as well. We will be providing ADA accessible path, ADA accessible spaces, as well as new ADA improvements along the frontage of the building as well. And then again, just noting there are separate entrances for both the uses. They will not be sharing the same entrance. In terms of some general improvements to kind of note, we are decreasing lot coverage, which is great. We're not including the synthetic turf or the playground as part of that. The playground is considered impervious surfaces, and that's both in our lot coverage calculation as well as our stormwater report. And kind of with all that said, we are slightly decreasing the lot coverage by about 718 square feet, which is below the requirement. We are proposing 40 new spaces, as well as new striping, new signage, and new markings to kind of help customers and help people utilizing the facility. We're going to be maintaining the ingress along Morris Avenue. And I'm not sure if I previously noted it, but Morris Avenue is a county road, County Route 651. So the right of way, as well as the kind of the driveway on Morris Avenue, is under their jurisdiction. We have filed an application with them and we are working with them. One note while I'm on the kind of the topic of the right of way, as part of the county comments, they have asked us to rebuild and reconstruct the sidewalk as well as the curbing kind of along all of Morris Avenue. And the applicant has agreed or will be agreeing to make that change. So I think that's a really nice thing to note that really isn't represented in what we're looking at today, that the kind of this entire 225 feet of frontage along Morris Avenue will be reconstructed in accordance with the county standards as well as the driveway. In terms of egress, and again, access will be highlighted by the traffic engineer. We are kind of maintaining the Gates Avenue egress. We are providing new signage, new striping, new markings to kind of help people that are leaving the site. Kind of just to highlight the playground, again, we mentioned it was included as part of the impervious calculation, and it is about 6,100 square foot play area. It has been, and kind of it was shown on the plans, that it is broken up into 3 areas: an infant and early preschool area and a preschool area. You know, any questions kind of on that can be kind of answered through operational testimony, but the playground is kind of shown at the rear of the first floor addition. From an engineering standpoint, it should be noted that we are providing some landscape buffering 15 feet per the kind of the setback requirements for this accessory. On both Webster Avenue, we're providing a 15-foot setback, and from the resident behind, kind of to the plan south of the page. We are going to be providing some new landscaping, as well as, you know, trying to either maintain the existing landscaping there, or the applicant is, you know, more than willing to replace in kind and improve anything along that line. Kind of something else to note with the residential buffer is there's kind of 2 different fences out there today. There's I believe it's lot 23, but the resident along Webster Avenue, they have their own board-on-board fence. And then there is an older board-on-board fence that kind of hugs our property line. So what we will be doing is providing a new screen fence, or completely solid 6-foot high fence along the rear perimeter of the site. So we'll be keeping the neighbor's fence. However, we will be providing our own fence along the lot 23 line. And then if the fence, which I do believe is on our property, it will be removed and replaced again with a brand new solid screening fence there, which will be a nice improvement. In terms of other site improvements, we are proposing a 10-foot by 10-foot by 6-foot high masonry block trash enclosure. That's kind of located directly south as you go down the ingress driveway off of Morris Avenue. It is going to consist of a dumpster, and just kind of to note again, touching on the operational, but again, that'll be kind of more, can be answered by our operational expert. You know, all trash that's disposed of at this property will be put into proper garbage bags. It will be sealed, and it will be put into an enclosed dumpster. So, you know, there won't be any loose trash or open air trash. Everything will be sealed and put into a dumpster properly. There will be a private hauler that will be picking up trash in accordance with the city requirements, and the applicant will also comply with the city recycling requirements as well. And for a reference, you know, we anticipate trash to be picked up on average about 2 to 3 times per week. In terms of signage, I'm just going to touch on the kind of the freestanding sign, or the proposed monument sign. The applicant is proposing a monument sign at the ingress along Morris Avenue. It's located past the kind of entrance, and it's really the goal of this is to provide kind of a little bit more of a focal point, but more direction for passerbyers on Morris Avenue in order for them to kind of really see the entrance. So, you know, right now there is only one egress to the site that's on Morris Avenue. It can't be, the site again cannot be accessed via Gates Avenue or Webster Avenue. So the intention of this monument sign in the location was really set to, you know, help for pass-by traffic or destination traffic that's accessing the site, so that they can identify the site and kind of safely make the ingress movement into the site. Kind of touching back on the improvements we were talking about under the existing condition is the topography and the kind of the challenges that came with that. So kind of one of the first challenges is the kind of the play area. So what we've done is maintain the play area, maintains the same elevation as the first floor of the structure. And this is in order to provide a safe, direct connection to the playground, and kind of to avoid instances or areas that, you know, could be harmful for children that are kind of accessing the playground, and make sure that it's kind of an easy connection from the classrooms to the kind of the play area. What kind of comes with the play area being located where it is, you know, it is slightly above the grade of kind of Webster Avenue, and it's kind of slightly above the grade of the surrounding parking lot. So what we've done, and kind of based on a TRC meeting with the board professionals and taking in some feedback at that meeting, is what we've looked to do is create a tiered wall system to kind of help soften the playground view from Webster Avenue, and to provide, you know, some nice kind of landscaping element between the playground and kind of the right of way. So just for reference, the first tier, which is located, you know, approximately 3 to 4 feet from the right of way, is about 2.5 feet tall. The second tier, which is located, I believe about 10 to 12 feet back from there, is approximately 4 feet tall. And just kind of for reference from the sidewalk, this I know was requested by the engineer, the first tier is about 5 to 6 feet from the sidewalk. And then the second tier of the wall, which kind of abuts the play surface, that's about 16.5 feet from the sidewalk.
And the architect has 3D renderings, which will kind of help give a visualization of what you're talking about right here.
Correct. Yes, the architect will provide some more perspective type views for the board's reference. And then kind of just touching on the residential side of the play area. So the play area, again, is about 15 feet from the property line. There is going to be 2 fences between lot 23 and the play area. It's at least a 6-foot high board-on-board fence on the neighboring property. And then there will be an additional screen fence located on our property. And then what we're looking to do is kind of maintain and kind of clean up some of the vegetation that's on our property today, and keep some of the trees that are located at that corner. And then behind that, we're going to be proposing a screening of evergreens to kind of further help provide a little bit of screen from that play surface, or play area. And just to note that the wall along the rear property line, or the southern property line, is not as high as you see kind of near the corner of Webster Avenue and Morris. That's really the variance comes as you get closer, or the peak height of the fence and wall combination kind of is when you're at Morris Avenue and Webster Avenue, where you kind of get closer to the corner. Behind the site or to the south, that wall is only about 2 to 4 feet high. And again, for reference, there is a 6-foot high fence there that we are proposing to kind of further screen. So kind of while we're on the subject of topography, just want to kind of touch on one of the engineer's comments. As part of the project, we will require a plan certification for the Somerset Union Soil Conservation District. So I know there was a question about kind of the construction entrances. We are working with them, and as part of that approval, we'll get a permit for the final location. Again, as this is an adaptive reuse, we are looking to kind of maintain the existing pattern. So that's why we are going to kind of be keeping the ingress and egress locations. And then, you know, the applicant, and as part of our approval, we will note that, you know, a silt fence will be provided throughout the duration of construction as well. Kind of moving on to stormwater improvements on site, I just want to kind of highlight some of the benefits and some of the changes here. So again, we are decreasing impervious area. So you know, we're naturally providing, you know, some benefit in terms of water quality. We're naturally reducing runoff to the Morris Avenue system. You know, today, ultimately, all the drainage goes to the Morris Avenue system. It will, under proposed condition, we're maintaining those existing drainage patterns. You know, what we're doing is locating some new inlets within the parking area in order to kind of provide, you know, a really nice kind of conveyance system back there to collect all the stormwater. We're collecting the stormwater in the playground. And it will be kind of connected underground to Morris Avenue. You know, one note made by the engineer, and we're agreeable to kind of making the change, is there is a kind of a swale, a landscape swale we've shown behind the playground area along the southern property line. You know, today it was such a small amount of landscape area that we naturally were going to kind of let disperse to Webster Avenue, as, you know, the entire parking lot does today under existing conditions. But we're happy to kind of pick that area up with a yard inlet at the engineer's kind of recommendation, and we will pipe that to our system as well. So, you know, kind of the synopsis on stormwater is that, you know, we are kind of, when you compare pre versus post, we are decreasing impervious surfaces. So, you know, at no point in time will the post stormwater condition exceed the pre-development condition. So, you know, there won't, you know, this will be an improvement overall when you compare this site to existing conditions. And just to kind of note, we will be replacing the trench drain along Morris Avenue, which I kind of talked about as in poor condition, and we'll be providing kind of a new conveyance system. And then any roof leaders, existing or proposed, will be piped underground to our proposed storm conveyance system. So there won't be any kind of overland sheet flow kind of going off the property. And, you know, kind of to reiterate, you know, A, the way topography goes, but B, you know, the way the site is designed, you know, no stormwater runoff or stormwater will be directed or impact any of the residents behind the project. I think I've kind of highlighted most of the key kind of landscape elements. I'll just kind of touch on it before I continue to lighting, but you know, we are proposing new landscaping along the Morris Avenue frontage, along the building. Again, we're providing some, you know, great tiered wall system with some new landscaping to soften that Webster Avenue view. We're going to look to kind of maintain as much of this existing landscaping along the southern property line and kind of look to densify it a little bit with some more evergreens. And just in general, the rest of the site, we're providing kind of new landscaping. We're revamping what's out there. So I think it's great. Most, you know, for the most part, the site currently, it's a little bit overgrown. So I think this is a good opportunity, and we're kind of come in and revamp and propose some really nice kind of landscaping throughout the property, and including landscaping kind of along the perimeter of the site as well. In terms of lighting, I just wanted to kind of touch on this to highlight some of the additional testimony requested from both the zoning officer, planner, and engineer. So there's two main goals that came to mind when we're putting together this lighting plan is, you know, A, and I think the most important when you have a business or commercial use abutting a residential use is, you know, what can we do to minimize impact to neighboring residential properties? So the short answer there is, you know, make sure that there's no spillage on these residents. And, you know, per our lighting design and our lighting plan, there is no spillage on the residential properties. The second item, when we talk about a childcare use, but just in general, I mean, any use, any lot that has vehicles and pedestrians is providing adequate and safe lighting for the proposed uses. So that's kind of the second thing we look at when we're kind of providing the lighting here. So to kind of touch on the big picture of the lights provided, you know, all of our lights are dark side compliant. They're full cutoff downward facing LED fixtures. We're proposing 300K or 3000 Kelvin as the temperature of the light. So this provides, again, it's in accordance with the city standards, but provides a nice soft light, especially, you know, kind of based on our location. So, and all fixtures are shielded. And another really great way the applicant looked to kind of minimize this impact when we talk about these residents is we've actually lowered all the lights, and we've reduced the number of area lights along the residential property line by 50%. So not only are we lowering these lights that are along the residential property line, we're actually reducing the total number of lights that are out there today. So we also are proposing building mounted light just to kind of clear up some of that. So all the building mounted lights that are located along the rear of the building, they will be mounted at 12 feet. And again, they are full cutoff downward facing LED lights. And the building mounted lights along the front of the building, they'll be mounting at a maximum 15 feet, which is in accordance with the city standards. And in terms of the canopy lights, so there's a kind of a canopy, an existing elevated path that leads to the playground. So there is a kind of a canopy along this first floor addition, and it runs from kind of along Webster Avenue, and then it kind of goes into the sites almost as if like, you know, you're heading towards Gates. But there are some canopy lights proposed. That light source will consist of a soffit or a recessed fixture. So it will not be kind of directly visible to neighboring properties. So again, it is a recessed fixture that we are proposing. We are requesting some minor waivers in terms of lighting. I just want to be clear that the waivers have nothing to do with the kind of the locations of the residential property. So we're requesting a waiver from the maximum illumination for internal walkways and external walkways. And this is related to kind of the entry area behind the building or at the main entrance and kind of the area along the frontage of, along the kind of that canopy area. And again, that's just to provide kind of safe and adequate lighting for the site. And then in terms of hours of operation, the applicant will comply with the city requirements, and the lights will be turned off an hour before close of business as well. And just to kind of touch one last thing on kind of the lighting, again, just to note, the playground area will not be accessed at night or when it is dark, and there are no lights proposed anywhere within the playground area. So the playground area will not be illuminated as well. So again, we're reducing the amount of lights along the resident property line, and this playground area is not illuminated. At this time, that concludes my site testimony, my site civil testimony. If there are any questions, or Craig, if there's any questions you'd like me to kind of highlight, I'm happy to do so.
Well, I guess maybe we could just, we'll go over a couple things, and then for board member questions, and then Steve, I guess direction for you on how you'd like us to address kind of at least the staff reports that dealt with engineering. There was obviously some other questions in the staff reports that'll be addressed by other witnesses. But with respect to, you mentioned the wall and the tiered wall as well as the fence, and we're going to be seeking a variance with respect to that as to fence height.
Correct. The combined, there's a combined height, which is the wall plus the fence on top.
And can you just identify too on the parking buffer where that variance is and what that variance is?
I'm just gonna zoom into A2 for everyone's reference. So we are requesting a parking buffer requirement. So 5 feet is kind of required between properties. So that exists today between the office building and our parking facilities along the easterly or kind of planned east side of the page or right side of the page that we're looking at. So that exists today. We're maintaining kind of these parking facilities in the same place. And then in terms of the kind of residential zone buffer, that exists along the, kind of bottom of the page or bottom of A2 or the southern end of the page along the residential properties to the south. So that exists, again, that exists today. There is existing fence that's in poor condition, but we will be replacing that with a brand new kind of solid screen fence along that property line.
And with respect to the parking spaces, the plan sheet included a parking tabulation where 40 spaces are proposed, but under their ordinance, based on the square footage and number of staff, a minimum of 51 spaces is required, and we'll be seeking variance relief for that.
Correct. We will be seeking variance relief for the parking, and Matt Seckler will provide support for that.
And then also to the freestanding sign you mentioned, there'll be there will be a size and setback relief, which again will be addressed, I guess, through the architect's testimony as we go through the renderings, correct?
Correct.
And you had an opportunity to review the staff reports and board professional review letters that were submitted to the board as part of this application.
I did.
And I know some of your testimony try to highlight some of those comments. I just wanted to walk through some of them, at least with respect to engineering. I guess, Steve, I was going to go kind of in order by the table of staff reports that I received, starting with the zoning officer's review letter or staff comment letter of August 18th.
Certainly, I defer to the chair, but if I may express my own opinion, I always like to ensure that particularly the engineer go through all the reports and address all engineering testimony, and starting from the first and moving sequentially thereafter certainly works for me, but I'll defer to the chair.
I think at this point, let's see if any of the board members have any questions of this witness. His testimony was fairly long, And I think it'd be helpful if any of the board members have any questions. I can walk through the board member list and then we can go to the engineer's comments. Ms. Paulson Alvarez. Mr. Brinkerhoff.
Yep.
Oh, sorry, Ms. Paulson Alvarez.
You were asking me if I had a question?
Yes, any questions? Yes.
I have a question for Mr. Klein about, just to clarify the amount, the width of the green space between the office and the new spaces, and the green space between the residents of Lot 2 and the parking lot.
Got it. So I'll try to touch on it again. I have Exhibit A2
That's
up.
fair, but I didn't know how deep it is.
Okay. Yeah, perfect. So today there's parking spaces, and I kind of will break it down into two areas because there's kind of the playground area, and I guess it's proposed parking kind of along the bottom of the page, but it's parking today. So the parking that exists today that we're kind of restriping and updating, these 13 spaces, we're kind of maintaining existing setback. So it ranges from about 3.1 feet to 3.2 feet along the bottom here. And in terms of the playground, we're maintaining about 15 feet to the playground area from the resident. And today, just for reference, it's, probably in the range of, 5 to 7 feet, if not less. There's kind of parking spaces that are directly kind of headlight facing towards that resident along that property line.
Right. I was looking at Lot 2 only. The green space between the office building on Gates Avenue and your parking is about the same, like 3 feet. Because I think
Yes.
I read in our notes that it's only proposed to be 2.5 feet between this lot and between the residents and this parking lot on Lot 2.
So the distance between the parking kind of on the right side of the page or between Lot 2 and this adjacent building at Gates, that is about 2.6 to 3.1 feet. And that matches what's out there today.
Okay. And what is it supposed to be? I think our planner could tell us what it's supposed to be.
Believe the requirement's 5 feet.
So it's supposed to be 5 feet here between the two office buildings, and it's supposed to be 42 feet or something on the rear, right?
It's based on a width requirement of the property, 20% of the width of the property, I believe.
Which was?
I believe it's 42.5 feet.
Okay. So now we know what we have. Okay. Thank you.
All right. Mr. Brinkerhoff? Any questions, Mr. Brinkerhoff? All right, Mr. Drummond has recused himself. Mr. Delory?
Can you just go over where the garbage is being collected again?
Yes, so the trash enclosure is located, if you take the ingress driveway along Morris Avenue and kind of head straight south or to the kind of towards the bottom of the page, there is the kind of a masonry block trash enclosure kind of located at the plan south.
Mr. Chairman, I think I was on mute.
Sorry, Mr. Brinkerhoff. Mr. Delory, you,
I was taking out the garbage. Sorry, Jay.
all right, Mr. Brinkerhoff.
I'm sorry, I was on mute. Mr. Klein, can you explain the circulation on the site itself, both access, I can see where the access and egress are, but I'm interested to know how cars will circulate, in particular with the notion that we have a childcare center here, and how's that going to work? Where will cars come in? Where will they turn? How will they drop off children and pick them up?
And what I can do is I can explain in terms of kind of where they're located, and I'll let our traffic engineer kind of walk you through kind of the circulation in more depth, and I'll let our operational expert kind of walk you through how the childcare, operates. But again, so we're maintaining an ingress driveway on Morris Avenue where cars move through that driveway, and then we are maintaining kind of the Gates Avenue egress point. And so kind of the parking facility as it's shaped today kind of mimics, what's out there under existing condition. The same kind of idea for lot 2 where they have an ingress point on Morris and an egress point on Gates. But I'll kind of let our traffic engineer kind of highlight some of the interior access details for the board.
All right, Mr. Delory, if any other questions?
Nope, not at the moment. Thank you, Mr. Chairman.
Councilmember Little.
Nothing from me at this point.
Okay, Ms. McNeil.
I just want to understand along Webster Avenue, and you were explaining there were the tiers, and there's going to require a variance for the fence height. Is that correct?
So there's this playground, and again, I think the perspectives later on will help kind of the board see this, but there's the playground, and then there's this kind of a tiered wall system. So there's a kind of this first wall, which is about 2 to 3 feet, and then there's a second wall, I think 10 to 12 feet behind it to kind of break up that height difference. And then there is kind of a wall kind of along the structure, along this path, kind of along Webster Avenue, where one of the classroom kind of egresses to the play area. So
Okay.
fence on top of that. So kind of along the entire playground or the entire kind of play area, there is a 6-foot high kind of decorative iron fence. And this is for kind of a safety, more for safety to kind of keep this area enclosed. And so based on the ordinance, we are requesting relief, I believe, because of the combination of the fence and the retaining wall height. So that will be, and I think as part of the planning testimony, we can kind of go through the exact relief that's associated with it, but it's kind of the total height and the height based on the combination of it being a fence and wall.
Okay. Thank you. That was it.
Thanks, Mr. Mr. Perrell.
Yeah, can we just follow up on that point about the wall there? So essentially what you're doing is you're raising the level of the first building to coincide with the first level of the second building. So you're raising the retaining walls, correct?
So the
building
floors
on
will be
Webster.
matching, and there will be retaining walls for the kind of the playground, and then the walls, the foundations, I mean, they will be architectural and they will be extending to the ground, but there will be it will be retaining in order to maintain that elevation, correct?
Okay, so if somebody is walking down Webster towards Morris Avenue, correct me if I'm wrong, but it's not going to have the effect of like the Berlin Wall next to them of concrete and then another fence on top of that. So there's this massive wall on somebody's right.
So I think the perspectives again will help, but no. So the idea with the tiered wall is that kind of walking up Webster Avenue toward Morris, that tier wall will create that separation, and will kind of the landscaping that's in between will help kind of soften that visual that you're talking about. And then as you kind of around Webster Avenue, I mean, it's really at that point going to feel like a traditional kind of building. So there'll be kind of, it's not going to be a flat concrete wall. It's going to be kind of an architectural wall. And it'll be like architectural features kind of as you kind of go around the building that will kind of start to play with what's out there today. And then by the time you kind of make the turn, which again, the perspective will really help. You'll see the windows, and it'll really kind of help break up that space.
Okay. The only other question I have is, are you going to be in charge of the construction? Are you going to be the site supervisor, or are you not the person, or is there somebody else doing that?
My understanding is there will be a general contractor, and they'll have to comply with any requirements to have a site supervisor. In terms of if we provide and are more than capable of providing any construction oversight as required locally or per any applicable code.
Okay, the reason why I'm asking is because we now have our third application that's next to a school. So I guess when we get to the construction portion, we're gonna need to talk about flag people and how this is gonna be coordinated so we don't hit a kid.
We're more than happy to kind of work with the board professionals and anyone at the city to kind of ensure safety throughout construction.
Thank you.
And Mr. Klein, if I just may follow up on Board Member Perella's comment with respect to the grade and ensuring not only that the building addition is at the same first floor level as the existing building, but also too with the playground, ensuring that the playground's at the same grade level as the building where the students are. So when they're exiting, they're not going down steps or changing sort of grade, they're just walking out to a playground, correct?
Correct. The first floor and the playground are at the same elevation.
Right. Yeah, as just as long as there isn't this massive wall and it's half tunnel like when you're walking down Webster. I think that's the concern that people
Yeah,
have.
and
The
we
way
have-
that the application asks for the variance.
Yes, and I think that the 3D rendering will be very helpful when the architect comes to testify.
Okay, thanks.
Mr. Zucker.
The comments about grading were very helpful. I too read the application as asking for essentially a 14-foot wall, which I think we understand is not exactly what's being asked for. The rest of my comments actually are more having to do with traffic flow and drop off and those issues. So I'll look forward to further testimony.
Okay. All right, Mr. Fiore.
I don't have any questions here. I'm going to also have some questions relating to traffic flow and construction materials when the other experts testify.
Okay. Mr. Formicelli.
I have questions that'll probably be more relevant during the parking, traffic flow, and traffic and trucks delivery and volume later on.
Okay, great. Can we hear from our board consultants at this point, either Mr. Dorr or Mr. Burgess, or maybe Mr. Behrens if he's here?
No, Mr. Behrens is not yet returned. So I'll start. I just have a few questions. One of them actually does relate to this issue of circulation. And if you can answer the question regarding drop off and pickup, how is that going to be accommodated?
I will, I think that's again a better question for the traffic engineer and the operation consultant.
Okay. On the location of the dumpster in our memo, we pointed out that you're only 3.5 feet from the residential property line and about a little less than 30 feet, I think, from the house on that adjoining lot. Is there a better location for this dumpster?
We've really looked at the movement of the trash vehicle, and we feel this location provides a really easy movement and safe movement for a trash truck that would be accessing the dumpster. And again, the dumpster, this is a masonry block wall, 6 feet high. It has with a dumpster in it that closes, and all the trash will be sealed in appropriate kind of trash bags within this enclosure.
Will there be recycling, separate sections for recycling and whatnot in that area?
I know the applicant's going to kind of comply with the city requirements. I'll kind of from an operational standpoint, confirm with them how they handle their recycling, whether it's stored in the enclosure or somewhere on the interior.
Okay. Like so many of the other board members, a lot of my questions that were in my report all relate mostly to circulation and traffic issues. The one thing, I guess this is more of a heads up for that person who's testifying. You opened your comments by talking about how everything is spread out and it's so unlike a school that you wanted to dispel that notion that it's like a school. But could you elaborate a little bit, since you seem to emphasize that with starting your testimony on that issue? Could you elaborate on that a little bit?
I guess can you maybe ask the question in a different way? Is there anything direct?
I think maybe if I can give it a shot, Mr. Burgess. In the opening, you were talking about, this is not a school that, the school opens at 8 a.m. So there's a line of cars of people coming in to get the kids in at 8 a.m. Where here, not to testify for you, but there's a period of time, 6:30 to 9 a.m. where there's when the drop off begins. It's not everyone coming all at once. It's usually a stage schedule based upon ages and things of that nature. So if you can just maybe, I think that's what he was referring to.
Okay, will the traffic, that is correct. Will the traffic consultant then be going into some detail on how that activity will occur, or is that be?
Yeah, between our third witness, Matt Taylor from Primrose, and the traffic engineer, they're going to hit more the operational issues with respect to the school children, the age, what the school really does and how drop-off works, as well as the anticipated circulation and designated drop-off areas.
Okay, thank you. Then I'll hold off all my other questions to those two people. Thank you.
Mr. Dorr.
Yeah, my questions relate to the stormwater, and then I'm going to just reiterate the questions on the recycling, because I'm a little bit wondering if we're going to have a dumpster for garbage. I'm not really sure how the recycling is going to fit in there. So to hear from the operations people would be helpful. And then also from traffic to see how a garbage truck can in fact maneuver in the parking lot. But as far as the stormwater, could you elaborate a little bit on the materials that are proposed for the surface in the play area? Or has that been finalized?
I don't believe that the detail has been finalized, but we have, again, modeled it in the stormwater management report, or the stormwater design. And we have, in terms of lot coverage, considered it an impervious surface. So it's counted towards lot coverage. And then we've kind of modeled it as asphalt or impervious or kind of building area in our stormwater statement. So it'll either be a kind of a, compacted stone sub base with a synthetic turf on top, or it will be synthetic turf on concrete. I think some of it will come down to the final kind of engineering design on the wall system.
Okay, but it would be more than likely have an under drain, as you just discussed, that would then drain into the central collection system, and then that would go out towards Morris Avenue.
Correct.
And one of the comments that we had, which I think you mentioned about renderings, I'm assuming those renderings will also show the play equipment, and then I guess if there's any temporary and or permanent coverings proposed for that play area as part of the design. We've seen them in other daycare centers as well.
Correct. I believe there'll be photographs of the specific equipment proposed for this location, as well as some views of kind of what that equipment will look like.
Okay.
Yeah, the architect will provide that testimony.
Right, and I think the renderings that the board should see are of the two-tiered wall section by the playground, and then also that the section leading up to the entrance to the along Webster Avenue, where the wall and the fence will be fairly will be in the two walls will be one, so it'll be a high retaining wall, and you'll have the fence on top of that. So I think the board should see that as well. And then the only other thing I just wanted, you did mention that they're going to be rebuilding that trench drain along Morris Avenue, and if they could just confirm that in the plans, because I don't think that was really called out.
Got it. We'll note, but the applicant will agree to reconstruct that trench drain.
Okay. And then the other questions relate to everybody else's concerns as far as parking and then just maneuvering within the parking lot. So I'll reserve that for the traffic engineer.
Okay, I think we've gotten through all.
Mr. Chairman, excuse me, Mr. Chairman, can I just ask a question to follow up on what Mr. Dorr just said?
Sure.
Mr. Klein, what is the width from the building lot 2 to the parking spaces that are proposed next to the adjacent building? How wide is that area for a truck to come in?
The access aisle on the east side of the building, kind of between.
Yeah, the ingress from Morris Avenue going straight towards the dumpster.
Yeah.
So
Like
you've
the
got
drive
parking
aisle width?
spots. Yeah, what is the
Seven.
drive-in aisle width?
Can you just try not to step over one another? Thank you.
Sorry, it's 17.9 feet. And just for reference, we did, as part of the plan set, we did run I believe it's a 45 or a 50-foot fire truck through the site. And we actually showed that to the fire official, and they agreed that it was sufficient, and the fire truck had no problem kind of making that turn and accessing the site through that aisle.
Right, and again, this could be for the traffic person, but so the garbage truck has to come in, face forward, get the dumpster, and then back up without hitting, I don't know if that's just a parking spot or if that's an actual pavement there, if it's got to back in and then turn to leave to go out onto Gates, correct? It's got to make
Correct.
a K turn.
Well, there's no real K turn. What's really nice about this is the trash truck can drive straight down, slightly kind of back up in the drive aisle, again, not impacting or touching any parking spaces around it, and then kind of make a turn and head out towards the Gates Avenue egress.
Okay.
Which is a similar movement as the fire truck would have to make to get out of the site. It does kind of take that turn as well and exit out to Gates Avenue.
Okay, thank you.
Thanks, to the board members, and thanks for our board's consultants. Now it will be the challenge to get questions from the public. And the key to this is that the questions need to be directed to this witness, specifically related to engineering and civil engineering in particular. It's not a time for opinions or comments. It's a matter of questioning the testimony that he's given and clarification of that. So Chris, this is where our challenge comes in. We'd like each of you to have an opportunity to speak if you wish, or ask questions if you wish. Please say your name so that's clear and so that our board reporter can get that clearly. And so Chris, let's see if we can manage that.
Certainly.
Mr. Chairman, I apologize for the interruption, but before we go right to the public questioning, I just want to ensure that Mr. Giannetti will have this witness available to address the staff reports where they do need to be addressed by this engineer and perhaps will not be addressed by any of the other witnesses, even if it's a matter of just stipulating to conditions of approval should the board grant the application, so that we have that on the record. I want to make sure that happens, but I recognize, Mr. Chairman, we're running out of time this evening, and I suspect we certainly want to get to members of the public as many as we can. So I just want to make sure we have Mr. Giannetti making that representation that Mr. Klein will be available. Is that okay, Mr. Giannetti?
Yes, he will be available, and I believe too, from an engineering standpoint, you can either agree to or address a lot of the comments that were in the staff reports, at least related to engineering. There's obviously other comments related to circulation, signage, and whatnot, which would also be addressed by other witnesses. But
Just from a housekeeping standpoint, I want to make sure we get all the steps in there so they're on the record, so the board is covered. But we can do that perhaps later. I give it back to you, Mr. Chairman.
I guess I was assuming that we would get to the stipulations as we got through, completed all the witnesses.
Okay,
that's fine.
Yeah.
That's
right.
fine as well. Thank you.
Okay, so Chris, we're going to have members of the public have any questions for this witness.
Sure. It looks like, and I apologize for any mispronunciations, the Cohout family has a raised hand.
Hi, that's us up here. We have many questions, but as far as the planning goes, am I correct in that from the Webster side, the elevation is from the standard house size, almost a level and a half? It would be, say, into their second floor height, correct? Of a playground that they would be looking at now from their second floor, or a white fence?
Excuse me, I need your name, ma'am.
I'm sorry. My name is Eileen Cohout. It's K-O-H.
We just need your address as well. I believe the chair.
We are 9 Gates Avenue. We butt right up to lot 2.
That's fine. Yeah, we just need the
And
name and
we
address for
also own-
all people asking questions. You don't need to explain the address any further than that. I didn't mean to burden you with
Oh,
that.
no,
Okay,
and
but
we
you do
also
have the
own-
question.
We also own the properties of 3 and 5.
Right.
Good.
Okay.
All right. Well, thank you.
Thank you.
So that, and then my second question.
Well, you may
is-
want to wait till Mr. Klein answers your first question.
Okay.
Sorry, can you just repeat the second question one more time? Sorry, the
From
first
a
question.
perspective of Webster Avenue, that I get the elevation is tiered, but ultimately it's higher than most of the first floor homes would be. In other words, am I correct that this green structure of tiered walls and then the big white fence are going to be at a second story level for most of these homes? Because that does affect the lighting. Even from my property now, if I look over, I don't see Webster Avenue. I don't see the road. Those lights are now going to be second floor level
So
to my house and others.
I think I'll break it. I'll do my best to kind of answer it. So the playground is a slightly elevated surface. The grade along Webster varies from 270, 272 to 269. So there's about a 3-foot grade change from the intersection of Webster and Morris as you go down Webster Avenue, towards the residential properties. So the playground is elevated in comparison to Webster Avenue, which again is part of the tier system. I can't, there could potentially be some visibility from a second story window. We are, using screening elements. We are going to be landscaping. We're going to be maintaining kind of that existing vegetation. And again, today there's lights that are about 6 to 8 feet, if not less, along that property line that are floodlights. We're not proposing any lights along that edge of the playground. The closest light is all the way underneath the canopy of the building in terms of the playground, and that is a soffit fixture that's recessed within the canopy.
I'm also extremely concerned how a 6-foot concrete dumpster right up against the property line, first of all, wasn't, unless I misread it, which I will say we got our notification no earlier than the 20th. We may have gotten on the 19th. There was no variance in there for what is you're calling a 6-foot concrete structure on a property line that is already in questioned areas. So that is where I have the concern. As much as it is a turning around thing, I can tell you they're probably going to be here at 2 and 3 in the morning to pick up that stuff, which also is a noise issue as it butts up to a residential location. So I don't know how that was addressed in that respect.
Great. So I'll clarify two of the points there. So there is going to be a proposed solid fence, or a brand new solid fence along the property line. And then this is a 6-foot masonry enclosure that's kind of off of that fence. So there won't be kind of a concrete structure that is visible. And then trash, in terms of the trash operations, what the operational expert will touch on, is going to be picked up between kind of the city required hours. So there will be absolutely no trash being picked up at 2 a.m. in the morning. It will be done, during the day, during business time, in accordance with the city requirements.
In fact, city requirements are 6 a.m. to 10 p.m. for trash collection, correct?
Correct.
Or does that sound familiar?
Yes.
So
Monday.
it's just, I have a huge concern with that. And given the properties on Webster were afforded so much greenery and space provided between where they are, I know right now there's more than 40 parking
Mr. Chairman,
spaces
I apologize for
currently.
interrupting Ms. Koha, but just if I could be clear for all the members of the public, the way this works in a quasi judicial hearing is this is the portion to ask questions
I
only of the
understand.
witness based on the testimony. And the reason I bring that out for the benefit of everyone, I don't mean to single you out by any stretch, is that later on, when there is a public comment portion, I have to swear everyone in to testify under oath at that point. So we really do have to break up the questions of each witness from the facts that we want to testify and share with the board, which we need to keep separate. So everything has to be a question. And I apologize for the interruption. Please proceed. But if somebody else wants to ask a question, we have to get your name and address first, and the chairman will recognize you.
Mr. Cohout.
9 Gates Avenue also.
Thank you.
My question.
Yeah, we need Mr. Cohout's first name. The court was about to ask. for. Matthew Cohout. Okay.
We're good? So my question is, that cement structure is right on the property line. If I wanted to build a shed in my yard, I would not be able to put it right on the property line. Why is that not in need of a variance for that cement structure?
Just to clarify with the board, and I appreciate you bringing up that the masonry block enclosure is not on the property line. So it is kind of aligned with the concrete curb there. So it's located, a little over 3 feet from the property line.
So, Mr. Cohen, I understand your question. I'm going to ask Mr. Burgess, our planner, to see if he could address that question in terms of where that structure should be placed with regard to the ordinance.
Thank you very much.
We appreciate it. Thanks.
That's why I had asked the question about its location. I'm under the impression that the ordinance calls for a 5-foot setback. They're at 3.5 feet from the property line. So Mr. Klein is correct in terms of the setback, but I believe the ordinance calls for a 5-foot setback.
Mr. Giannetti, do you recognize that that's an additional, it appears that's additional variance that as the applicant you would have to seek?
If that is the case, if it's at 3.2 feet, then yes, we would acknowledge that a variance would be required for that.
Right, and
that the ordinance requires 5 feet.
And your witnesses will have to make the necessary proofs in this case if accordingly. And I will just say that for notice purposes for jurisdiction for the board, the catch-all language was included with the notice. The fact that this is one bulk deviation amongst many others, as well as major site plan approval and subdivision approval. Under the Perlmart case and its progeny, it would be sufficient to make that amendment right now, and the board would still have jurisdiction. The notice would still be sufficient for jurisdictional purposes. So that's one more variance the applicant needs to pursue. Back to you, Mr. Chairman.
Sorry, Mr. Chairman, can I ask a question because there's a buffer question in section 6 of 3.1 feet. It doesn't say what it's for.
I'm not sure where you're.
Section 6 of the proposal, it just says to permit a buffer of approximately 3.1 feet where a buffer of approximately 42.5 feet. What is that for?
That's the question that Ms. Balson Alvarez asked, which is basically if this building existed and you went to a rear property line, the buffer, according to the calculation, is 20% of the distance of the property depth, and that would be 42 feet. But given what you have in place today, you have roughly 3 feet of a landscape buffer that's there under the current conditions. If I answered that correctly, Mr. Klein, is that close enough?
Believe so.
All right. Okay, so Mr. and Mrs. Kohut, can we go on to another resident or another concern?
Yes.
Okay.
Yes, thank you.
Thank you for being here tonight and thank you for your question. Mr. Nicola.
Yeah, so next we have Miss Marvin, and then I also saw Mr. Rodriguez. I think your hand was up before. So we'll go to him second after Miss Marvin.
And Miss Marvin, please state your name and address. Maybe on mute, Miss Marvin.
Yeah, still muted. Hold on.
Sorry. Can you hear me now?
Yes.
Okay. Elizabeth Marvin at 40 Madison Avenue. And I have a question about a comment. I can't remember the gentleman's name, so I apologize, made at the beginning of his presentation where he said that the pickup and drop off points would not coincide with the schools. I want to know, I would like to know where he got this information, because when I would going into the city, I was dropping my children off between 6:30 and 7 o'clock in the morning, which coincides with the high school. And if you work at 9 o'clock in the morning, you're going to be coinciding with the elementary school down the street. So from my calculations, from having had children and knowing when these pickup and drop offs occur, I'm just wondering where he got the idea that this pickup and drop off would not coincide while young children are walking up and down the streets.
Thank you, Ms. Marvin. Just to kind of clear, in my testimony, I did not mention anything about the timing in comparison to a school. I just, again, noted that this is a child care facility, not a school, and they do operate differently. So I did not state that on the record.
Well, I believe the comment was you will not have the same spikes in congestion as a school, was the comment that I wrote down. And that comment to me is incorrect. So I'm just wondering where you're getting that thought from. Because when pickup and drop off occurs, it's when people are working. It occurs generally, and I'm going to generalize, within a 1.5 hour to 2 hour time frame in the morning, and then you have a similar time frame, although it's a wider time frame in the afternoon. So there actually are spikes in congestion, and they do coincide with the school, the high school, which is on the right, the elementary school, which is a couple of blocks down the street to the left, and then you've got a school across the street. You've got two schools across the street, and they're all dropping off and picking up at the same exact time as the drop off and pickup would happen with the children.
I think that would be best addressed through our operational testimony as to the exact times of when drop off will be occurring, as well as when pickup is. And again, I think Mr. Klein's testimony at the very outset, and also, and Mr. Klein, you could testify too, but you and your office have done a number of these Primrose applications, so you're generally familiar with the operations and know that the point of the testimony was that it's not like a school where it opens at a particular time and that's when everyone's getting dropped off and there's a line of cars. It's a larger window in the morning and also a later and larger window in the evening. We will have more testimony and specifics as to that with our operational witness.
Okay. Ms. Marvin, that was a good question, and it will be addressed further in additional testimony. Any other questions that you might have?
No, I think the rest of the questions would apply to and I'm not sure who it is, the person who did the traffic study and the traffic.
We're going to hear from him, Mr. Giannetti, is that right?
Probably not this evening, but you will hear from him at some point.
All right. Ms.
He
Marvin,
is our fourth witness. So.
All right, we'll keep going. Ms. Marvin, thank you for your question and thank you for attending tonight. Mr. Nicola, we had another Mr. Rodriguez, maybe?
Yes, that's correct.
Yes, my name's Alexander Rodriguez. I'm at 38 Webster Avenue. The house directly in front of Webster Avenue, so I think I'm most impacted by this new addition. I guess my biggest concern, there's a lot of concerns I have, but one of my biggest concerns obviously is I'm going to be looking directly at this two-tiered retaining wall. 14 and a half foot high. It's having like a big trailer parked in front of your house 24/7. I realize it's a two-tier, but I guess one of my questions is, just where you came up with that 14 and a half foot number. You mentioned the 2.5 feet for the lower wall plus the 4 feet on the lower wall. That's 6.5 feet. But when I look at the elevations, I'm looking, at the finished floor versus the grade. I guess it says 7.5 feet, and then there's another 6 feet So when I add 7.5 and 6, I guess I'm getting 13.5, where you're requesting 14.6 foot high. So I'm not exactly sure where you got that 14.6 feet. And along with that question is that 6 foot high fence along the playground. I'm just wondering if that's going to be like a see-through fence. I think it's indicated as an iron fence, but I wasn't sure if that fence was going to be solid or not. But obviously I'm really concerned with that big retaining wall part right in front of my house.
Mr. Rodriguez, you're lot 3 there, right behind the muffler Midas shop. Okay, just to be
That's
sure.
correct.
Thank you. Yep. Mhm.
So what I'll do is I'll reshare my screen just to kind of help talk through the two questions. So I think just the first point to kind of clarify is there is no side yard setback along Webster Avenue. Buildings are permitted to be, I believe, 42 feet within this business district. However, we are looking at the kind of the retaining wall aspect of this at this point along Webster Avenue. So the highest point of the wall and where the variance comes from is it's the combination of the wall and the fence on top of it. So what we're doing is taking the point from the highest point, which is this corner right here, kind of the underneath kind of the overhang of the building. There is this we're considering, and is technically kind of a retaining wall in order to provide this kind of safe egress path to the playground. So if you were taking the height of the wall plus the 6 foot fence on top, and that is where the 14 foot comes from. What we've done and what we've really looked to do is, if you've noticed, is once along Webster Avenue here, you see the back of the auto repair shop. If you kind of draw a line straight across the back there, what's really nice is we've kind of made sure that this 2-tiered wall starts before you get back there, so that view corridor or that element is kind of, once you get behind that commercial zone, we have this 2-tiered landscape wall that provides us kind of a softer feel. So again, the maximum height of the variance really comes from the wall up towards kind of the corner at the building, just because we're providing this egress. But as you go down, that's where you kind of hit this tiered wall, which again kind of softens, kind of that visual corridor along Webster Avenue.
And in regards to the fence?
The fence, I believe, the architect can confirm, but I believe it's a decorative iron fence and it is see-through.
And I guess my other question was in regards to that dump truck. Is that dump truck supposedly going to back up into that trash recycling thing? Is that the idea? Because if it is supposed to back up, then it's not. Again, I don't think there's any turnious radius for it to back up. It would have to back up.
I think we could let Mr. Klein answer it, because it's not. It's a front loader.
It'll be a private hauler, and it will be front loaded, so it will not have to do any kind of multiple movements.
And in regards to the hours, because again, Midas has a big trash bin as well, and someone mentioned they come at 2 a.m, and they absolutely do come at 2 a.m. Obviously, it has nothing to do with this, but they absolutely do come at 2 a.m. because I hear the Midas trash truck come at 2 a.m. and do their trash cleanup at that time at night.
I can't speak for the Midas property, but again, that is not in accordance with the ordinance. Our applicant will be doing trash within accordance with the ordinance requirement. And again, no trash, absolutely no pickups will be done at 2:30 a.m. as part of this application.
Yeah, thank you. And I do have additional concerns, but those are my questions for now.
Okay. Thank you, Mr. Rodriguez. Thank you for your questions. Good questions. Mr. Nicole, anyone else dialing in, calling in, raising hands?
Yeah.
Yes.
I heard a yes from someone.
Yeah, we have a few. I'm looking at Chris and Rebecca Murphy.
And one of the things I might mention, if we could, and we haven't done it yet so far, so we've been well disciplined, but please, if you've had a question that was asked previously, please don't re-ask the same question. That will keep things moving along. Thank you.
Hi, I'm Rebecca Murphy. I live at 8 Webster Avenue.
Yes, Ms. Murphy, what's your question?
So based on the new build of Building 1, are there any changes to the line of sight to Morris Avenue from Webster Avenue?
There are not. So we're kind of doing two things. We're maintaining the site distance requirements for the city, as well as the proposed footprint is not encroaching in the site line of where it's in the, basically either within or along the same footprint where the existing building was.
With the landscaping as well?
There is no landscaping within the sight line under proposed condition.
Okay, thank you.
Thank you, Ms. Murphy.
Okay, next is Mr. Enos.
Yes.
Yes, thank you. This is Michael Innes. I'm a resident 23 Webster. Just to piggyback, and I think Miss Mervin or Miss Marvin's comments about and I believe the testimony was there is no surge traffic in the mornings because it's not a school. I guess to clarify Mr. Gianetti's comments as well. My question is going to be more for Mr. Sackler, but I just want to put Mr. Sackler sort of on notice about this. I'm curious how he's going to square, or how Mr. Gianetti squares Mr. Klein's comments about no surge with the last paragraph on page 2 of the Stonefield analysis, where it says that the proposed development is expected to generate 172 new trips during the weekday morning peak hour and 173 trips during the weekday evening peak hour. So I'll leave my comment at that, but I can't really square those two statements in my head.
Mr. Ennis, we will get the answer to that question. I guarantee it.
Thank you.
Mr. Nicola, other questions?
Yes, Mr. Catone.
Hi there, Peter Catone, 25 Webster Avenue.
Yes, Mr. Catone.
Thank you, Chairman. My question for Mr. Klein is, what's the green space on the site currently? Is there a calculation for that? What the site currently has in green space?
I guess for clarification, when you say green space, are you referring to
Impervious coverage, or excuse me, pervious coverage, grass, shrubs, trees.
There is an impervious coverage calculation that's on the bulk table on sheet C4. So under existing condition, 85.3% of the site is covered by impervious surfaces, and we are decreasing that. So under proposed condition, 83.7% is covered by impervious surfaces.
So you're adding 2%.
Impervious.
You're adding 2% to the green space, basically.
No, we're decreasing.
No, we're decreasing.
Okay, so we're losing green space in our neighborhood.
No, we're gaining.
Gaining green space, reducing impervious coverage.
Fair enough. Fair enough. Is there maybe the board can advise? Is there a requirement on a new construction? Seeing as you're demolishing the existing site, I would imagine the proposed addition is really new construction. Is there a requirement for the applicant to meet a minimum green space requirement?
The ordinance provides that there's a maximum lot coverage standard of 90%, indicating 10% of the site has to be green space.
Okay. So it seems the applicant is within their right to add or take away the green space then.
Yeah, that is correct.
Very good. Okay, thank you. That's my question.
Thank you, Mr. Catone. Chris, any more?
I don't see any hands raised in the chat.
I see Elliot Fishman.
There's a few people, yeah.
Okay, and then I also see Peter Meiswitz as well, who can go next.
Yes, Mr. Fishman.
Hi, Elliot Fishman, 34 Webster Avenue, a couple down over and across the street from the proposed development. My questions, I have a lot of comments for later, but my questions pertain to two issues right now. One is the trash, which I don't feel was fully answered before. What is the earliest drop-off time of this facility?
believe the hours are 6:30 a.m. to 6:30 p.m.
And what time would staff need to arrive to receive the earliest drop-offs?
Believe that could be confirmed operationally. My guess would be before that time, but that's a better question for our expert.
Or would
I'm
it be?
sorry, what was the answer? You cut off a bit.
I would believe it would have to be at 6:30 or earlier, but I can't fully answer that question.
Well, I hope it would be before 6:30 if the students arrive at 6:30. And to reiterate, the town code is the 6 a.m. is the earliest trash can be picked up, right?
Let's see, someone.
That is my understanding. That was in the zoning officer's review, staff memo.
And would the staff at the facility who would be there to receive the earliest children's drop-off, the 6:30 a.m. drop-offs, they presumably would park in that parking lot sometime between 6 a.m. and 6:29 a.m.?
I think these questions are kind of more appropriate for our operational and traffic engineer.
Well, the point I'm getting at is the applicant aware that the previous tenant to that building regularly picked up trash at 4:30 a.m., woke up the whole neighborhood, and there's a stack of police reports and for the previous tenant for trash pickup before 6 a.m. And are we inviting this all over again, waking up the whole neighborhood?
Well, I think we'll have, again, we heard the testimony that the applicant will comply with the town's ordinance, so that should be hopefully seen as an improvement. And we'll have, let me just finish, and we'll also have operational testimony as to when Primrose believes would be the best time for trash pickup, which will obviously not be very early in the morning or late in the evening. And that testimony will be presented at that time.
Not to belabor the point, but with a parking lot that presently holds 40 cars being expanded to one that would hold 52 cars, and the current tenant could not have trash pickup after 6 a.m. because the trash truck in the 40-car lot could not maneuver around the cars that were parked. Has the applicant taken that into consideration?
I think that's, again, you're testifying in your question. I think it's more appropriate for a comment. We will have an operational witness testify. We will have a traffic engineer testify. I think that will be hopefully addressed through their testimony. And if you have other testimony you want to provide through public comment, we can address that at that point.
My second set of questions regards the residential buffer, which were kind of skipped over. What is the requirement for a residential buffer? Was it 5 feet or 43 feet? I didn't quite get that.
I think that, well, I think Mr. Burgess can testify, but I think there was two different things there. There was the residential buffer, which is essentially a buffer landscape between residential and a commercial use, and how much space it was. And I believe the testimony was it's 42.5 feet based upon the calculation, because it's based upon lot width. Then there's also, as Mr. Burgess identified, a separate setback requirement for, I don't know, specifically for trash enclosures or accessory structures of 5 feet.
Okay, so I'm not talking about trash enclosures. Now I'm talking about the residential buffer facing Webster. What is the requirement and what is the variance asked for? Could you clarify that, please?
There is a 42.5 foot residential buffer, and we're 3.1 feet.
So 42.5 versus 3.5, about a 90% reduction, if I do my math right.
That's the existing.
It's an existing.
It's existing condition.
It's an existing condition.
All right, I have no further questions.
All right, thank you, Mr. Fishman. Anyone else, Mr. Nicola?
Yeah, we had Peter Meisowitz next, and then Ranoji Mukherjee.
Okay.
Hi, good evening. This is Peter Misiewicz. I live at 28 Webster Avenue.
Could you spell your last name, please?
The last name spells Misewiczz, and the first name is Peter.
Thank you.
And what was the address again?
28 Webster. I have a question that might be a little bit too early. It's about the traffic. Was it any traffic study done, how the traffic is gonna affect overall the traffic on Morris Avenue during the peak hours? And the second one, if the traffic will be so congested, are there any plan to put the lights at Webster? Because right now it's almost impossible to make a left turn during the peak hours in the morning or in the afternoon.
We have a traffic engineer that will be testifying.
Okay, that's my question was a little bit too early, and then I'll get back later.
Okay. Thank you, Mr. Weiswitz.
And is Ranajit here?
Yeah, hi, this is Nandita Mukherjee.
Could you spell your name, ma'am,
is
please?
N as in Nancy, A, N as in Nancy, D as in David, I, T as in Tom, A.
I'm sorry, is that your first name, ma'am?
Yes,
So that's Nandita?
correct.
And your last name, ma'am?
I'll spell M as in Mary, U, K as in Kevin, H as in Harry, E, R, J, E, E.
Great, thank you. And your address, thank you.
1515 Gates Avenue is the fourth house from the proposed structure.
Thank you.
Thank you, Ms. Virginie.
So I share all the concerns that were mentioned by Eileen Kohut, and specifically on traffic. So we were told that this child care center is different from school. So can you help us understand how this child care is better in reducing traffic congestion as opposed to this being a school?
We have a traffic engineer that will be addressing that. He's a couple witnesses away.
Yep. We will be giving testimony to answer that question, ma'am. Yep. Do you have any other questions?
Yeah, I have several of traffic, noise, and light questions.
Okay.
So first will be the buffer question. Sorry about that, the residential buffer. So for Gates Avenue, can you tell us what is the required buffer and how much buffer is being proposed now?
Mr. Klein, you're on mute.
Yeah.
Where on Gates Avenue are you referencing a buffer requirement?
So the buffer between the property that is being proposed and where the first house begins.
So the residential buffer requirement previously mentioned applies to the residents behind us. So we are a commercial zone that abuts a residential district to the bottom of the page. So it applies to kind of both those properties along the bottom of the page.
So there's no buffer requirement between the property and the first house on Gates Ave?
I'm not, maybe I'm not following exactly where you're referencing.
I think are you referring to the residential home that abuts our rear property line?
Mm-hmm. Correct.
I think that was already testified to a few times by Mr. Klein, that the buffer is 42.5 feet, which is based upon a calculation based upon the lot width. We are maintaining the existing buffer of 3.1 feet.
Okay, so from 42.5, it becomes 3.1 feet, correct?
Well, it doesn't become, it exists.
It already exists.
Yeah, it's based upon, the buffer basically means you can't develop in it, whether it's the curbing, the parking, the pavement. and it's already developed with curbing, parking, and pavement.
Okay, all right, thanks. I didn't understand your answer well, but anyway, I'll take it.
All right.
Okay, thanks.
Thank you. Mr. Nicola, anyone else, or are we ready to move on?
I'm looking through the participants. Just hold on.
Mary Pinella has a question, I believe.
I do.
Okay, yes.
Is that
Welcome,
appropriate?
Mr. Pinella. Can you
Hi.
give us your address and spell your name for us?
The last name is P as in Paul, Anella, first name Mary. And I have a address in New Providence, New Jersey. I am one of the owners of the Midas and the ice cream shop next door.
Oh, okay, great.
So
Can you just give us the address in New Providence, street address, please?
1253 Springfield Avenue,
Thank you.
07973.
Okay.
My career was in licensing childcare centers, so I'm retired now, thankfully, excuse me to say that. It was a wonderful experience, but I noticed there is an entrance coming in from Morris Avenue. Is that going to be kind of a turnabout, or are people going to be walking in and out of that entrance? It was on the Webster side of the street.
There's no entrance on the Webster side. What you're looking at is there is a door there that leaves the kind of the first floor, but it's fenced in. It goes directly to the playground area, so no
Okay, that's
from the
good.
public can access from that side.
I was going to ask you about the capacity, the proposed capacity, and whether or not children will be dismissed or discharged directly to parents. They won't be walking in and out on their own.
I can definitely let the operator touch on it, capacity, but no, children aren't allowed to leave the facility alone. They have to be, an adult has to come inside and
Right.
pick them up directly and then walk them out of the facility.
Okay, and I'm asking that again because there's a very popular, beloved ice cream shop on the other side of that Midas, and it's great business, but I was envisioning children walking through Midas or walking, what kind of flow that was going to be also. But so thank you very much for.
Ms. Pinella, I won't recuse myself from this testimony, but I've consumed large quantities of ice cream from that ice cream shop.
I was a 3-year-old when that was being put up. I remember my dad there. So I consider this a blessing, being able to talk to you all and seeing this going on. But yeah,
It's a Summit institution.
that's right. Thank you. That was all that I had. I just got concerned for the.
Thank you for being here.
Thank you.
Thank you for your question. Chris, how are we doing there?
Looking through now. Don't see anybody right now. Is there anyone in the public that has an additional question?
Okay, it's a question of just this witness now. We've gotten through one witness so far, and it's almost 9:45. We're going to try to stop at 9. Mr. Giannetti, I know that you have other witnesses here, and I've got some other business I'd like to do here tonight for the board's sake. And I guess the question would be, if we pushed it to 10 o'clock, could you get another witness in, or are we at the point, would you prefer to stop at this point? And I don't want to rush anybody or do that, but Mr. Warner, do you have any thoughts or advice for us or the council?
Well, I know the board has further business that's probably going to take some time, and certainly there was a commitment made by the applicant as well to allow members of the public an opportunity to retain counsel, experts, what have you, in the interim. So maybe it's best if we stop 45 minutes later than originally proposed, as opposed to continue another 15 minutes. All that said, I defer to the chair.
Yeah.
And if I may, Mr. Anderson, I fully understand if the board wants to stop and get on with this business, and we're fine with that. My only thought would be our next witness is the architect. If nothing else, just to get his exhibits entered and see the renderings with the elevations, because there's a lot of questions, and though obviously we'll deal with it more at the next meeting, at least at this meeting, the board will at least see the renderings and get a visualization of what we're talking about, and it might help for the next meeting.
I think that's a fair request. I think it would help for the next meeting, and I think it would give some of the residents a better sense specifically of the tiered area on the street there. So let's do that, and we'll try to wrap that up by 10.
Great, thank you.
Chairman, this is Bridget. If we wrap it up in the next 15 minutes, that's okay. Otherwise, I will need a break.
Okay,
That's
all right.
2.5 hours of writing.
All right, that's it, Mr. Giannetti. You have
Got it.
14 and a half minutes.
At this point, I'll call Mr. James Cassay, please.
Hi, my name is James Cassay, 17710 Detroit Avenue, Lakewood, Ohio, 44107. I have a bachelor's of architecture from the University of Cincinnati. I'm a licensed architect in New Jersey, and I have testified multiple times for boards in New Jersey.
And your license remained current, and you've been accepted by boards as an expert in the field of architecture?
Yes.
At this point, I ask that the board accept him as an expert in the field of architecture.
Do the board members have any questions of Mr. Casey?
Could I just ask the last time you testified on a case in New Jersey?
As in Bedminster, that was right before COVID, probably in January. And I was in Holmdel in, I believe it was October 2019.
Thank you.
Any other members of the board have any questions? All right, Mr. Cassay, we're recognizing you as an expert. Please go ahead and proceed.
Sure, Mr. Cassay, too. You have experience also. This is not the first Primrose school that you've worked on. You have a relationship with the school and have worked on others as well. Is that correct?
Correct. I have experience in the childcare industry from an architectural perspective for about 13 years, and have worked with Primrose for about 6 of those years.
Great. And I know it'll be a tough task. What I'm going to ask you to do is well, let me ask you first. You or someone in your direction prepared exhibits in connection with tonight's meeting?
Yes.
And if you could just briefly, you can share those exhibits, just describe them very briefly. We'll get them marked, and then we will save a lot of the meat and potatoes for the next meeting.
Okay. Do you want me to do that sharing screen? So you can
Yes,
see 'em?
please. Yes. And I guess, Mr. Warner, too, these are a series of exhibits. So do you want to mark the set A3, or do you want to individually mark each?
How many are there in a series?
There's 8 pages to it.
If they're individually designated, then you can mark it as a compendium A3 and just identify each one as you go along.
Okay, great. So then if we'll mark this as exhibit A3, you can just talk through your 8 sheets and describe, you know, the first one, second one, what they are showing.
Okay. The first one is EX1. That's an existing conditions showing the existing building floor plan and some photographs of the exterior in its existing state. The second sheet is A4.0. This is color 2D exterior elevations of the north and west, and also has a monument sign elevation and a wall-mounted sign elevation. A4.1 is also color 2D elevations of the south and east elevations. RE1 is a perspective rendering of the view from Morris Road looking southeast. RE2 is a perspective rendering of the view from Morris Road looking southwest. RE3 is perspective view from Webster Road looking northeast.
And just sticking with that one for a second, that's showing the tiered landscape wall that there was a lot of questions and discussion on along Webster Avenue.
Correct.
Okay, next.
RE4 is a view from the parking lot looking north, looking at the entrance to the childcare facility. And PE1 are some example photographs of the playground equipment that is being proposed, broken down by age group.
And those are, I don't know if prototypical is the right word, but standard playground type equipment for a Primrose school or used at other Primrose schools.
Yeah. Correct. And then I'll also have floor plan exhibits, FP1, which is the proposed floor plan, and FP 1.1, which is the second floor of the existing building.
I guess maybe if you can go back to the 3D renderings for just 1 minute.
Okay.
So again, that going to what was RE4, I believe, down below. That is a view from essentially, if you were standing just to the left of the dumpster at the
Correct.
property line with the lot that's located on Gates Avenue.
Yes.
And that shows also, the entrance one. I think we can see where the entrance is to the office building. If you can kind of just use your cursor and highlight where the entrance is to the Primrose School.
Yeah, the entrance to the office building is here, and the entrance to the Primrose School is a little bit, it's kind of concealed behind this column, but it's in the corner here.
And is there any way to access the playground area from this parking lot, or is it only from the interior of the school?
It's from the interior of the school, but there is a emergency egress gate over here to the left of this gable element that's needed for life safety.
And then go up to the next one, RE3. And the green canopies, those are the canopies that will be over the playground equipment, even though the equipment's not shown, at least giving a perspective of what the canopies will look like. Is that correct?
Yes, correct.
And then if you go to RE, well, maybe just describe too the variance for the wall height, as Mr. Klein was testifying to. If you can maybe highlight that area again, where the kind of next to the tiered wall, where the covered or enclosed walkway area is.
Yeah, so grade does slope down a little bit as you go towards Morris Avenue. So at the corner, the wall is 2.5 feet, and then 4 feet, and then a 6 foot aluminum vertical picket fence. And then as it comes down, those walls merge into one for the walkway. So this covered canopy is over that walkway. It's the end of the corridor from inside the school, and is part of the emergency egress path. So the solid retaining wall is, I don't have the exact height, but roughly 7 feet at this point with the 6 foot fence.
And then RE2.
Mr. Giannetti, can I just ask
Sure.
Mr. Casay 2 questions, because it came up through questions from the public. As I understand it, the overhang that we're looking at the back of the rendering behind the fence there is where the soffit is, that the only light that will be on will come from there and not on the playground. Is that correct?
Correct. And there, I'll zoom in a little bit. There is, the soffit is recessed behind some perimeter beams, so it's not, you're not directly seeing that soffit.
And I'm not trying to give your testimony, Mr. Giannetti, but if you could look, Mr. Casay, to the right, far right of that rendering, there's a gap there or a space between that wall and where the property line is for the adjacent home. Could you just talk a little bit about that and what is being planned there?
Yeah, it's better to see it in the site plan, but there's two existing trees, which you can see. Sorry, this keeps.
Now you're referring to Exhibit A2?
Yes, sorry. There's two existing trees and then a row of new trees along the fence line that's in front of the existing vegetation to the south.
Okay, thanks, Mr. Giannetti. I just wanted to make those points and be sure everybody understood. Yeah, thanks.
And then if you can go up to the next rendering. And again, this is coming along Morris Avenue, going in a, always getting mixed up, I believe, a westerly direction.
Yes.
Northwesterly or northwesterly direction.
Yes. The
And that's-
monument sign
that's-
is the proposed new sign. And then there's signage in an existing location where building signage currently exists.
And then up to the next.
Sorry, Mr. Giannetti, sorry to bother you again.
Sure.
That is the driveway that will users will be turning off Morris Avenue, turning into that driveway. Is that correct? And that's the driveway that goes through the site to access the parking. Is that
Yes.
correct? Okay, all right. All right, thank you.
It's the main entrance to Morris.
Yeah, okay, thanks.
And then up to the next rendering at the intersection of Morris and Webster. And I believe with this rendering, there was that question, there may be existing today a entrance at that kind of corner. And you've kept the architectural feature, but is there an entrance now at that corner?
There is no entrance. The height of the retaining wall is carried, that material is carried around the building. And there's a decorative landscape planner at that element, at the gable element, but there's no access from to the sidewalk or to grade from Morris Avenue or
Webster.
Webster, thank you.
Again, Mr. Casay, we'll probably ask you, upon further testimony to talk a little bit more about what those materials are. We won't get into it tonight, but if you could be prepared to talk to us about what those materials are on the various surfaces of the building, that would be helpful.
Absolutely.
Mr. Chairman, if I may, just procedurally, Mr. Giannetti, the last two exhibits that were shown, the floor plans, FP 1 and 1.1, by my count, those are documents 9 and 10. I suspect they're not part of Exhibit A3, but we should mark them as Exhibit A4. Is that correct?
Yes.
Thank you. Thank you, Mr. Chairman.
Thanks, Mr. Warner. Thanks.
So again, yeah, Mr. Chairman, we'll be prepared at the next meeting to have Mr. Casay go through in more detail, obviously the elevations, the rendering, the playground, and get into more detail, but we at least wanted to get these exhibits marked and give at least some visual for the board and the public in advance of the next meeting.
That was very helpful, Mr. Giannetti. And so Mr. Seckler will be talking about traffic, and Mr. Taylor can address the operational questions that have come up.
Correct.
Okay, very good.
And if I may, Mr. Chairman, my understanding is all 4 witnesses will be brought back. Is that correct?
Yes.
And right now we have a special meeting scheduled for September 23rd.
Yes, that's correct.
Yes.
We'll notice for that. And before we conclude this, I just wanted to note for the record that Mr. Stephen Forbes did have a hand raised earlier. So perhaps we could get to him at the beginning of next meeting or something, or just wanted it reflected in the record.
Mr. Forbes, if it's the last one tonight, let's ask Mr. Forbes to speak up tonight, and so we don't have anything hanging over. I think it's only fair. We've all been at this for a while. Only take another minute or two. Mr. Forbes, are you able to ask your question?
I'm here. So it's Stephen Forbes at 28 Montrose Ave. And I was just, I thought about the residential buffer that you're speaking to, existing versus the current ordinance. And where I was a little confused is I think you said you weren't developing in the buffer. But I think the current structure that houses the trash, right, that 6-foot mason structure, does not exist today, right? So that would be developing within the buffer. And I guess, so is that correct? And is there any other development being added into what the buffer requirement would be for the residential area?
I believe that question is for Mr. Klein.
Sure.
Great. Yeah, I think just to kind of clarify, I think what we're saying is, under existing condition, there's only about 3 feet of landscaping that exists today. And we're maintaining that 3 feet of landscaping. So we are proposing improvements that are within the 42.5 feet. But in terms of, there's a 3-foot buffer today, and we're kind of maintaining that buffer. We are improving it by providing a new kind of 6-foot high fence and some new shrubbery in there. But I think that hopefully answers your question.
And Mr. Forbes, we have pointed out that may need to be added to an additional request, variance request, what you're pointing out tonight.
But that I guess that's 6 foot. So the only development that would be transpiring within that 42-foot buffer would be this 6-foot housing for trash.
If you were to go 42.5 feet from that property line, we are doing other improvements, which include the play area, landscaping improvements, lighting improvements, restriping and relocating some curbs for the parking. But when you focus in on the buffer itself and what that is, there's a 3-foot buffer. We're kind of maintaining that existing buffer.
Thank you for the clarity.
Okay, all right. Okay, we need to give Bridget a break tonight. And thank you for hanging in there so long, Bridget. We appreciate that. It's been a tough one. And Mr. Giannetti, is there anything you'd like to say to sort of wrap things up from your side tonight? And then Mr. Forbes, Mr. Warner may have some additional instructions.
No, I think, we've heard a lot of the questions and we're prepared to answer them if we got to them tonight, but we will be prepared at the next meeting to, make sure this, a lot of these questions on circulation and operation are all answered.
Okay. Mr. Warner, any words of wisdom?
We can only try, Mr. Chairman. I'll do my best. Just want to clarify again, though, for the record, that this matter is going to be carried without further notice to the next specially scheduled meeting, which will be scheduled for September 23rd, Chris, at 7:30 p.m. with the expectation that it will, as this meeting was, be a virtual remote access meeting with a web-based platform and telephonic participation as well. And all that information will be provided for the special meeting notice will be published certainly, but it'll be provided for, no doubt, on our website. Would that be correct, Mr. Nicola?
Yes, that's correct.
That's all I have, Mr. Chairman.
Okay, well then, Mr. Giannetti and all of your witnesses, thank you all for coming tonight. I'm sorry we couldn't get it all concluded, but it's a bit of a complicated project, and we look forward to seeing you at our next meeting. And all
Thank you.
residents, we want to thank the residents and property owners for attending tonight too. It was a long night, and we appreciate you being here and the questions you've asked were very, very thoughtful. So we look forward to seeing you again in September.
Thank you for your
Thank
time.
you, Chairman, members of the board. Appreciate the time.
Then, Mr. Nicola, with regard to our DRO, we need to give Bridget a break, but do we need her here for that at all?
No, Bridget, you're all set actually. So
You can go home early tonight, Bridget.
Thank you. Yay for
always
DRO.
great to see you.
All right, thank you very much.
Good night, board members. Chris, I'll be in touch with you.
Okay, so yeah.
So
Thanks, Bridget.
let's take a little bit, like maybe a 5-minute break here, give everybody a chance to get up and stretch.
Yeah.
And then we'll get back to working on the DRO. The two things we want to talk to tonight about the DRO are basically the what we discussed last week, the ORC1 versus the R10, and then a little bit about the definition of breweries. And Krista Anderson has been on hold here since 5 o'clock this afternoon, so we'd like to address the brewery thing first so she can depart soon.
Chairman Anderson, can I ask a question?
Absolutely.
Just a quick, I know the board, this meeting's moved to September 23rd. Is this going to be third in line now, or because you had mentioned the other two applications are being carried?
Mr. Rodriguez, that's a great question. Mr. Nicola can probably answer that from a procedural perspective. I'm not sure, actually.
Well, at this point, this is the probably most likely candidate to be heard first. I mean, the 83 Maple application is still out there at this point. I don't know if they'll be requesting another adjournment from that date, but we have not received the revised plans for 43 Woodland yet, so those would still need some staff reviews, and whenever they do file those plans, and Mr. Maynard gets those to me. So as of now, at this moment, this is probably the first, if not second, I would say, on this agenda.
We realize, Mr. Rodriguez, that there's a lot of interest. And so by the weight of the numbers that you have, we don't want to keep more people waiting than less. So that would certainly be a factor.
Thank you.
Yeah. Thank you for your comments, questions. Okay, so let's just take a 5-minute break and we'll be back to tackle the remainder of the DRO. And I see Tom Behrens is here and he's all fired up.
Which means I'm going to say good night and leave you in the capable hands of Tom.
Yeah, Joe, thank you very much. We appreciate the time you spent with us. And Chris, I think you can depart as well.
Okay, thank you, Mr. Chairman.
All right, excellent.
Good night, everybody. Good night.
Bye. Okay, we shall return. Hey, Amanda, is that your office or your home office?
I'm at work.
Really?
Yes.
Well,
It's got a whole new camera system, so I was playing with it.
I see. Well, I certainly hope Mr. Warner appreciates the hard work that's there.
I'm sure he does, wherever he is.
He's probably not serious.
Oh, he's muted. Can't hear you, Steve.
You're muted, Steve.
I said, I'm sorry, I couldn't hear that. There's a very bad connection.
Yeah. Somebody's working really hard there.
Greatly appreciated as always.
Yeah. Good. Well, we'll see if we can get the gang back together here shortly. I was thinking about the fact that we're not all in the same place, and that with regard to the applicant and its counsel and their people that testify, the various witnesses that they have, it seems like, pretty much they can stay at home, right? Or, Amanda, of course, in her office, but in a lot of cases, it looked like people were working from home, and, it's still bad to be here at 10:15 at night, save and except the fact that Krista is at City Hall 10:15 at night. Thank you, Krista. I'm so sorry. But, it's somewhat easier, I guess, maybe for some of the people giving testimony, that they don't have to now get in the car and drive for 45 minutes. Krista, you have my permission to take the day off tomorrow.
Oh, thank you. I was kind of planning on Thursday, actually.
Okay. You tell Michael Rogers that the chairman of the planning board said, give her a day off.
Thanks.
Okay, we're waiting for Mr. Fiore, Mr. Zucker, and Ms. Paulson Alvarez. Oh, There's Mr. Perella. All right. Paulson Alvarez. Hi, Jennifer. Now, Beth, when we talked last time, you were in a car driving home from North Carolina. Were you delivering a student or picking up a student and bringing him home, her home?
I was delivering a student. So Kara has started her senior year at Duke, but they juniors and seniors are fully remote. So she's in an off-campus apartment. And then my sophomore son at Vanderbilt's taking the semester off. So
Wow. Yeah, it's a challenge, isn't it? Yeah.
Yep.
Well, I have a son who's at Seton Hall getting a master's degree, and he's at home, and they've gone all remote, except they're going to get together 4 Saturdays, some kind of social distance, gigantic classroom, 4 Saturdays in the course of a semester. So roughly every 3 to 4 weeks. Yeah. So assuming that nothing bad happens, maybe they'll have to quit that too. I don't know.
Yeah, it's not easy.
Let's see, Mr. Zucker and Mr. Fiore.
All right, I'm back.
There's Mr. Zucker, how are you?
I am here. Fiore's here.
Oh, hi, Rich, how are you doing? Good. Okay, well, I think the gang's all here. So with regard to, let's, Krista, I'll leave it up to you. Which one you'd like to address first, the ORC 1 R10 or the breweries? Chris was telling me that you have you and Tom have a very elegant solution, or as it relates to the breweries. And I don't know if Andy Perella has been involved or not, but I'd like to hear. You can pick whichever one topic you want to start with first.
That doesn't bother me. Either one doesn't matter to me.
I will start with the breweries. At least we can have some fun, right?
Well, it would be a pretend, right?
Amanda has contributed to that as well, and both Amanda and Steve have contributed to the R10 ORC as well too. So it's lots of hands in the pie.
Actually, very informative. What Amanda sent right after the last meeting with law and all. It was. I really was happy to read that because I never had it all in the same place before. So earlier today, one of our engineering aide, actually, intern, did the map of the CRB and then radii around the one brewery that we have approved that's under construction, and it was sent to everyone. So I don't know if everyone got it, even realized that it came to them or had a chance to look at it. But there's also a green outline of the CRBD. So
I got mine, Krista. I got mine at 3:09 p.m. from Christopher Nicola. Forward radius map.
Yep. So I think it's pretty obvious that we would definitely want any other breweries more than 250 feet away. When I looked at where they could be if they were between 250 and 500, obviously there's a lot of lots there. The issue is that there could also be multiple breweries in that, in that 250-foot wide semicircle, because they could always be also 200 or 250 feet or 500 feet from each other. Within 500 feet of the existing one, more than 250, but less than 500. But they could also be more than 250 and less than 500 from each other. So I think that's probably something that the board isn't really especially inclined to want.
So if you went out farther, the radius, for example, at 750 and at 1,000, 1,000, you could still have a second one, right?
Well, if you go then beyond 500, so
Yep.
between 500 and 750, that's another semicircle that basically goes from Springfield Avenue all the way from Winberry's
Yep.
that semicircle that then goes to the lots that are on the east side of Beechwood.
Yes.
So-
At 750, you mean, or at 500.
More than 500.
Yeah, okay, yeah.
So that seems to me to be a fair distance. What I would say is within that 250-foot wide semicircle between 500 and 750 is 250 feet. Within that semicircle, you see the big lot that's 2704 lot 10?
Yes. uh-huh.
Okay, so I think what we would want to say is that they have to be more than 500 feet from the nearest one, but that they can only be a lot on a lot that doesn't have any part of it less than 500. So that would eliminate anything in that block 2704 lot 10.
Okay.
Then it would eliminate 1908 lot 1, which is the Bank of America, I think it is.
Within the 500 feet, you could have 3.
It would be more than 500, but not necessarily more than 750.
But I mean, you could have 3, one that exists plus 2 others at 500 feet.
You could have one that exists and one that was more than 500 feet from the one that exists.
Yep.
But I don't think that you could have another one more than 500 feet from the new one that was.
It wouldn't be likely because if you put another one, if you're moving left to right and you put another one, if the bull and bear is the one in the center there and you move to the right and you put one there, if you had the 500 feet, you wouldn't technically, I don't think you'd still be able to get another one in there.
I don't think you would.
You'd be at the very far edge. So it's still
Well,
anywhere from 500, 750 and 1,000 are technically probably going to be 2.
I don't know, I guess I'm not reading the document. It looks like at 500, you could have 3 or 4.
Well, if you look at the bull and bear, which is that centered diagonal,
Yep.
and then you were to go 500 out, and let's say you put another one at the corner of Beechwood and Springfield that says 7 in the middle.
Yep.
That's it. You'd have to go another 500 feet from that.
That's
to
the
the right.
1,000-foot. That's the 1,000-foot line. Yep.
Well, they would have to be 500 feet from each other.
Right.
So even if you're at the 1,000-foot line, the very top corner of Springfield in the CRBD, because this line intersects all these other lots pretty much, it would just be the
Susan.
top and the bottom.
I have a question. I thought we were trying to distinguish between what we wanted in the actual downtown CRBD versus a larger one that we want to push to an industrial area, similar to what New Providence has. So
Yeah,
I
I think
think
that's
I don't get the whole 1,000-feet circle because, well, I do and I get it, but if we limit it to the size, then they can't go to a Bank of America. They can't take the entire Bank of America building if we say you can only have 4,000 feet. But I don't think, we certainly don't want something out at 1,000 feet that's not an industrial area.
Actually, Andy, I think maybe we should start with saying it was the radius, and then Krista has other variables that relate to what would be appropriate in a downtown. This radius is just checking the box of Chairman Anderson's speaking to how many could happen in the downtown.
Yeah, we have 2 issues.
The other criteria is coming up next.
Yeah, we have
But
2
so
issues.
I-
We
yeah,
have the
I
industrial
understand.
and the CRBD. We have 2 locations.
Right. So let me ask this question then. If we are trying to limit something in the number in the downtown area, how is this? What is the concern with the number in the downtown area? Are we concerned that there's going to be too many breweries?
Yes.
Or if there's more restaurants in the downtown area and you can bring your own alcohol, what's the difference? So why are we trying to?
You have. Well, no. What's the?
You have taxes being collected by a tenant moving in and paying rent. And so if you have restaurants, are we going to limit the number of restaurants that you can bring your own alcohol in? Is the issue we want to limit the amount of alcohol by limiting the amount of breweries? Because then you can't have any more restaurants. gotta bring your own.
No, you're conflating these things. The question is, how many breweries should be in downtown Summit? Period. That's the only question.
And just to be clear, city staff just heard the planning board talking and just went back and came up with some criteria for the board to discuss. Whether or not they should be limited would be the board's decision. This was just a way to do that, to look at that.
Yeah, no, I get that. I understand that.
So let's have Krista go on with some of her additional thoughts related to the CRBD.
So I looked at what might be an appropriate distance from one to another. I looked at what kind of frontage maximum should there be facing the street, because I think last time we talked, there was a sentiment that, you know, we didn't want to have anything overly industrial facing a street and impacting the streetscape. Of course, as I thought about that, I thought, well, we don't limit the maximum width of a restaurant that faces the street. So then I sort of put the frontage max in the back of my mind and thought about what percentage of the overall floor area on the street level would we want to have as the tasting? Because as Andy said, you know, it's kind of, we know they can't serve food, but we like to have businesses in the downtown. We like to have a variety of businesses. This is potentially a business that would bring a lot of people to the downtown, and especially in the evenings maybe, and on the weekends. So if you assume that the major part of the manufacturer, if you will, would be in the basement, if there was a basement available, and on the first floor, or maybe even the second floor, if the basement wasn't available. But thinking about the first floor, the ground floor that everybody cares about as what does the downtown look like? Would we care if there was a fair amount of space in the streetscape where people were sitting and chatting and having recreation? And so then I thought about, well, what would an appropriate proportion of the first floor space be? If you had a 30-foot wide frontage and it was 40 or 50 or 60 feet deep, let's say it was 60 feet deep, that would be 1,800 square feet. Out of 1,800 square feet, just hypothetically, what would a comfortable amount of the tasting space be? 25, 30, 35% of the floor area. So instead of actually saying X amount of square footage in terms of floor area, because do we really care what the floor area is in the basement? Maybe we don't even care what the floor area is on the second floor if somebody wanted to have their manufacturing operation. What we care about, I think, is the first floor. And what we care about is to make sure that there's space on the first floor where people can see in the windows and they can see something inside that looks interesting and that they might want to try. So then I sort of didn't think too much more about the maximum width, but I thought more of the percentage of the entire first floor space, what maybe should be the tasting space is what I call it. And I think maybe something like probably 20, 25%. And then the rest of it in the back can be the processing area. So I throw that out. The other problem with talking about a maximum frontage is that if you look at the map in the swath that's between 500 feet from Bull and Bear and 750 feet from Bull and Bear, almost everything in there, or the great majority of them, they're corner lots. So if you said you had a 20 or 30-foot wide frontage, that would be on both faces of both streets, and then you'd really be limiting it. So I'm not sure that the frontage is really as critical now as I thought it was, a week or so ago. But I think it's more important to deal with the percentage of the area on the first floor that is the tasting area. Now, I don't know how anybody else feels about that, but.
So if we
something that-
follow up on that, and if we hypothetically were to say that we don't want the overall size of the business to be, let's just say hypothetically 4,000 feet. And if you take a property like you described, which is 30 feet wide by, let's say 60 feet deep, and you have 1,800 feet, and you compare that, and I think, Paul, you probably thought this was similar sized, Fiorino's. It's probably 1,800 feet. So if we have a proposal that you have a 4,000 foot building and 2,200 of it has to be manufacturing either in the basement or an upper floor, what is wrong with having an 1,800 square foot, essentially tables, and perhaps a little bar where people go up and they have stuff on tap? It's no different if people are bringing their own food, if it's classified that way as a brew pub. If people are walking in with their own food, sitting at 30 odd tables and eating their own food and talking and socializing and being served the brewery's beer, it's no different than a restaurant. It's just serving the beer. What we wanted to try and prevent, I thought too, was we don't want that brewery in the downtown to then say, hey, we're going to try and grow this and take away from the 1,800 feet and add 2 more fermenters and then try and do off premise. And then we've got box trucks, and now it's something that should really be in the industrial zone, similar to Untied and New Providence. So I think we got to kind of look at it as if it's a brew pub, and this is my personal view, and you can all object to it, but my personal view is if we look at this as a brew pub in the downtown area where people are bringing their own food and sitting at tables and a bar, Fiorino's has a bar. The difference between the Fiorino's and a brewery is the brewery's serving its own beer on tap. Everybody's sitting in a restaurant style atmosphere, eating and drinking. I don't see the difference. I think what we wanted to eliminate is what we said before, is we don't want a downtown CRBD brewery to think of itself as distribution beyond the CRB. We want their product to be consumed on premise or for takeout purchase. If somebody wants to come in and fill a growler or buy a 4-pack of cans, they should not be prohibited from that because it keeps them in business.
Andy,
But I
do you
think
feel that the notion of tying how much space you have where people have to sit helps draw the distinction of what is your intent here? Are you here to really make beer? Because if you are, we have an industrial area. But if you want to serve customers, we're requiring a certain customer area to sort of delineate that you're in the downtown, and therefore I think, and that's.
I would put the restriction on the percentage of floor area that can be production, not the percentage of floor area where people can sit and bring in their own pizza or that. That's the way I would prevent in the downtown area, the actual turn it into a production. And to your point, exactly, Matthew, if you want to be in the town of Summit and you want to be like Untied and you want to be distributing more beer, then go find an industrial property in the town of Summit that accommodates that. If you want to be a brew pub where we talked about what we just did, then we'll welcome you in town. But I would limit that to 4,000 feet. would not want to see the Bank of America building turned into a big brew pub and all that. If we want to keep these things smaller and manageable, and then for my opinion is do we want to limit the number of them? I mean, there's only so many that are probably going to come here, but if we want to be safe and not say, oh my God, we've got 900 nail salons and 50 brew pubs, we could do that. But again, I mean, we have to also be conscious of the future of retail, and how many of the establishments that are here now are going to continue, and what is the the social atmosphere and the purchasing of the downtown. It's a lot of restaurants, and it's a lot of people wanting to go out and hang out. And yes, there are other retail, but who knows what 5 years from now it's going to be.
And Andy, if I could add to that, Andy, I agree with you, but you're also going to find, just like restaurants turn over very quickly and fail, you're going to find these the same way. And that Bull and Bear may not be there 3 years from now,
Yeah.
but somebody else may come in and reuse that for their
Right.
own brewery. So
If they don't make a good
prepare for some of that
product, then-
organic growth and evolution.
Yeah.
So Rich Fiore wanted to say something too.
I
Thanks,
don't know.
Andy and Paul. I think you're heading in a good direction.
So I'm familiar with out of state with some, similar places. And what they do is they actually have menus from the local restaurants in their vicinity. And so you can actually order from those restaurants and then that gets delivered to them. So it could definitely help support the local restaurants. I don't know if there's anything we could put in place to encourage or require that, because one of my concerns is I don't think you want people coming in to drink beer and just bringing in a pizza, as opposed to sitting in, the ideal scenario would be that they're sitting in the pub and they're ordering from one of the local businesses in downtown Summit, one of the restaurants. So
yeah,
is
but
there-
I'm not,
Yeah.
I don't think the state law lets us do that. I think the definition that they're allowed to bring in, given what we were given from Amanda, we can ask them to put things in and say, hey, but that might be going against they're not allowed to have a relationship with a food truck. They're not allowed to quasi be supporting, sponsoring, working together with, I don't even know if they're allowed to put menus in. If they were allowed to put, go ahead, Amanda.
we have that at the Elks Club and at Flores.
The Elks Club
They're
is
ordering
a
from
different
Fiorino.
license.
Else is different.
The
Andy,
Elks Club is
I
a
know from
totally different
experience with
license.
Twin Elephant that they do not allow keeping of menus or ordering food.
Yeah.
In them. You can bring it in, but they cannot carry them in.
Councilmember Little has something she'd like to add here.
So we had in council a similar discussion regarding retail sales of alcohol, because we had Cambridge Wine, which just opened this week, and we had a lot of discussion about that. And we actually, they had applied for a variance because the old ordinance said that they couldn't operate within, I think, 250 feet or 500 feet. And we ended up changing it because it was going to prohibit any other retail sales from the entire downtown. So when you put some reasonable limit on it, the downtown area isn't that large, first of all. So if you put a reasonable limit, I don't think we have to go to 1,000 feet or something else. And I think the market forces also come into play here, and a brewery isn't going to want to open right next to another brewery. They're going to look for a good location that's somewhere else. And we have and the same thing happens with restaurants. We don't have restrictions on restaurants. In a restaurant, they look around and see where, what market they can bring. And if they're serving something completely different, they'll go right next to someplace else and they look at what's going on. So I don't want us to get too in the weeds of managing how many brew pubs should be in the downtown, because I agree with Andy and maybe Paul that these are service restaurant, it's a service. It's similar to a restaurant, similar to a retail sale. We do allow the multiples of those in the downtown, and it's a business coming in. But I do agree completely with Andy that what we want to be crafting is something that prohibits commercial distribution. And so are there other ordinances or are there other examples where that's what's, and I don't really mind like how much of the space is devoted to tables or anything else. What I want to prohibit them from doing is commercial distribution.
Well, so Beth, just to pick up on your point there, so
it eliminates that type of large scale sale outside of the storefront, rather than getting into the weeds about specifics.
I think we're all probably in agreement with that. I'm a little bit oriented towards not having too many of these things, but I understand the point that you're making. The market will determine it to a great extent. And the concern I have is 4,000 feet seems a little big to me. And Jay had sort of thrown out, what is Fiorino? And somebody said 2,500 and 3,000. We've kind of been bouncing back and forth. 4,000 seems pretty large to me to limit them to no distribution, if you follow what I'm saying.
Right.
Bullet Bear apparently is intending to do distribution, if I understood that correctly, Krista. So we have we probably don't want it to be 4,000 feet. Again, I think.
But
maybe
but
it's
Bill,
just
Bill, the
hang on a
Fiorino's
second.
is
Hang on a second, thank you. Maybe just, I'm sorry, maybe it's just a situation where it's, you're just, by taking the distribution out of it, you've already created a size limitation because it can only be just so big. Sorry, Andy, I just wanted to finish that.
No,
point.
I was going to say sorry, Bill, I didn't mean to cut you off, but Fiorino's, when I'm talking about Fiorino's, I'm talking about the seating in the bar area, not including the kitchen and all of that.
Okay.
So you have to remember, if you reduce the size of it, fermenters are big. They're a certain size. And again, if you go walk it, you can't do it now, but if you've walked Untied, if you walk some of these craft breweries, they take up a fair amount of space. So just to be able to make enough beer to serve an 1,800 square foot restaurant, assuming you have a good beer and you get a good product in there, you're going to need almost 2,000 feet of production. And plus, you also want to have, remember, there's storage of the barley, there's storage of the yeast, there's bottles, there's packages, there's all of that needs to be done in a smaller scale, right? So if you've ever toured a brewery, you go to River Horse down in 20,000 feet down at exit 8A, it's a massive production. Scale that down, you still have all the same things. The beer's got to go in a can or in a bottle, or there's got to be area in the back of the bar for taps. So what I'm saying is if you look at just Fiorino, when you walk in as a customer, you're looking at probably 1,800 to 2,000 feet. Paul and I could go in there and count the ceiling tiles and tell you the exact size of just the restaurant area. That to me is what the front of the house should look like in a brewery.
Okay.
No more, no smaller. And the back of the house, if it's 2,000 feet, and that gives them the capacity to sell enough beer on premise and some walkout purchases of, now most craft breweries are doing cans and 4-packs or some growlers. That will, in my opinion, 4,000 feet with no more than 1,800 to 2,000 of it production, 2,000 production, and the rest of it front of the house, right? Seating area. I think we solve this problem, and we let the market, to Beth's point, we let the market and Summit dictate how many of them want to come in here and how many of them survive. And it's not just the market, it's also the nature of the buildings, because to Krista's point, they're probably better finding a building with a basement to put this in. Putting fermenters and stuff on the second floor, it's the rent is more money if you do that in the downtown area.
They're heavy.
It's heavy. It's
Also-
maybe it's better for some venting or stuff, but it's heavier. And then they're paying basement rent versus second floor rent, which in the downtown of Summit, second floor rent in some of these buildings could be $50 a foot.
So Paul,
So
you want to
it's-
say something, Paul?
Yeah, I also, to add on top, Andy, we haven't seen anyone economically prove themselves yet to be a viable business. This Bull and Bear
Exactly.
may not even work. They've never done it elsewhere. So it's hard to say what actually does work economically. It may have to be something that's twice the size, or at least capacity wise. It may have to be a different model entirely. But
I think to your point, Paul, an
Andy,
Untied is going to.
Andy, if you've seen one of this scale, maybe you can speak to that. But
Well,
most
not
people-
in the downtown. There are
Right.
very few in the ones that are in downtowns. There was one a long time ago in Princeton. It was a bigger operation, which
Right.
we're all talking about we don't want. The craft breweries that work, that want to distribute and such, Untied is a perfect example in a local area. Elephant is selling on their own, in their own, and successful.
Right.
People like it there because you can, like I said, I've only gone there once because I don't like their beer. I find it very fruity, but I saw a lot of people sitting there eating, hanging. I go to Untied. I like their beer. During the pandemic, they had a side door open. You walked up, you bought their beer. They have outdoor seating. It's an industrial setting. The tenant next to them is a tire factory. Nobody cares. They're not going down there for the downtown ambiance. Inside, it's a great place. They've got cornhole. You do the little tour. They have their own bar with 20 beers on tap. It's a big area. They're now allowed to have their 2 TVs. If that wants to come to Summit, then we should be encouraging that in our industrial areas.
So Jennifer, you had a comment. What I'd like to try to do is get to a point where we can kind of agree as a group on what this downtown you know.
That's where I was going. That's where I was going.
It should look like, you know.
Right. I was thinking, okay, so
try to
now that
narrow
we've
this
heard all
down.
these ideas, I mean, I will glom on that for a we should try and draft something for downtown and something for the light industrial. I am in the camp of don't do a radius restriction or a distance restriction, just eliminate that. I am for having some sort of reference to having seating near the storefronts so that when you're walking down the street, you have that activity. Whether it's a percentage or not, I don't know if we need it, but it's just, you know, seating, and the patron's experience needs to be visible from the storefront. And then to the very important point of it not becoming a brewery where we have box truck after box truck and too much production downtown, because that would be not ideal. Didn't Amanda tell us that there was a restriction on the number of barrels that you could make anyway? And so that would be self-correcting?
I think that barrels for distribution, if I'm not mistaken, but go ahead. Yeah.
Amanda, what was that?
I believe it was 300,000 was the limit, but there's also limits based on what the fee is. So they might just have to pay a higher fee to get up to 300,000.
300,000 what?
That's huge.
That's yes, but if we limit this to a square footage and of 4,000 feet and 50%, no more than 50% is production, they are not going to be able to make more beer.
Okay, but
they're also going to hang on a second, Jennifer. I don't mean to cut you off, but they're not going to be able to comply with the waste usage and the water usage and all that. There's all kinds of restrictions if you read these things. So it's very simple. If you just say in the downtown area, it's no more than 4,000 feet and no more than of the square footage is no more than 50% of the square footage, the 50% is production, you've eliminated it. And if the business wants to come in and try and say we want more, they're going to have to get approval.
I hear you. So maybe to Krista's point, we could limit the production area, because you're saying 2,000 beyond. If you keep the production to 2,000 square feet, you're going to eliminate the production overage problem. But I don't want to restrict the total square feet because we have a lot of larger spaces that we have trouble getting tenants.
Okay.
So I don't want to then make them, again, white elephant spaces because they're just that much bigger and we can't lease them. You know?
I'm okay with that too. I'm perfectly okay with that.
Okay, whatever mechanism that we can use to make it not into a box truck, you know, down the alleyway, 20 a day, you know, is what we need. Maybe it's just the 2,000 production area limit.
But do we know,
I'm fine with that.
Angie, do we know it's 2,000 feet? I mean, you may talk to somebody who says we actually need three.
I would make them come to the board for a variance and prove their business model and what property are they going into. And again, to Paul's point, we're going to know very soon, well, the Bull and Bear, the pandemic is not going to help them, but it may. I mean, if you look at the people lining up at the window outside the Summit House to get cocktails and stuff, I mean, you never know. But I'm just saying, Jennifer makes a very, very good point. If we limit production to 2,000 feet and let's say somebody thinks they can make enough beer in 2,000 feet to fill 7,000 square feet because they're going to have 7,000 people sitting and eating, well, that's a big restaurant. And would we turn down a big restaurant?
Andy, I just don't want to arbitrarily say 2,000 square feet when we don't know it's that. Like, we should have some type of experts say, this is what you need to serve 1,800 square foot patron space.
I agree with you. That may be true, but here's the problem. The problem right now is we have a definition of a brewery, and we've all recognized that tomorrow Anheuser-Busch could come in and buy out the Bank America building and say, I'm putting all fermenters in there and we can't stop them. So I would, for this meeting and the fact that we have to get this to the council, and you can all say that I'm an idiot and we don't need to do that right now, but I would think we should at least have some kind of definition and we address it later at another meeting or at another time if we have to, or if we need an expert to do it. But I'm just going off the Bull and the Bear of 4,000 feet.
Where did you get the 2,000 square feet?
Okay, the Bull and the Bear is approaching 4,000 square feet, but that is because The first floor is 1,200 square feet. The basement is the rest of it.
So maybe it's 3,000 feet is the number then. Maybe,
Well,
I mean, yeah.
But they're in the distribution business, and we don't want people in the distribution business.
Well, so
Well,
They're in the retail.
all of them are licensed to distribute. Is that not right, Amanda?
They're all allowed to have warehousing capabilities.
Right. That's part of what they're required to have to get this special license. So the square footage then is something that does limit it. But if you, I'm thinking that if you say 4,000 or 6,000, whatever, if you limit it to how much square footage can be on the ground floor, and then assume that the rest of it is going to be either in the basement or the second floor, and then create the, whatever the appropriate percentage is on the ground floor for the tasting area. Because if you say 4,000 square feet and you've got a building footprint of 2,000, that means all the production has to be in the basement and all the tasting has to be on the ground floor if it's 50-50. And I don't know that we need to do that.
yeah, we'll see. So the problem with that is, and hypothetically, let's say the Summit House went out of business. Summit House has a pretty big bar. Summit House's bar is probably in that 18 to 2,000 square foot area, and most of it is all first floor, right? The kitchen is on the back portion on the first floor. So if the Summit House went out of business tomorrow and a brew pub came along and said, hey, we really like this, we'll convert the kitchen to brewery and we'll keep the bar and all of that, I would think we would want them there, because the people sitting in the front through the glass windows are going to be the same people with their own food, just drinking the beer from the place. So,
One other thing to think about from a capacity standpoint, Andy, to your point, might be almost more of a cubic foot equation, because if the ceiling heights are not great in a little basement that's 100 years old, they may not be able to get the appropriate equipment to put a certain amount of, or have a certain amount of capacity anyway.
That's a construction code issue.
Well, no, but they're interrelated, because it's just how much.
John Zucker wants to say something.
Well, I have a question. I mean, and I really don't know the square footage of the average building in town. What's our worst case scenario if we just said 50% of the building had to be, no more than 50% of your building could be manufacturing? I mean, is there a 20, do we have a 30,000 foot building that we would have to worry that it would be, that 50% of that would be industrial? You know, I mean,
those are office buildings. Those are office buildings.
Buy 3 of the properties or 4 properties in a row and you demo them all to make a gigantic brew pub. And then it's
So I have a question for Amanda. Amanda, are you telling me that this license allows people to distribute, and regardless of what our zoning ordinance might say? In other words, if these people come in with a certain license, we can't control the distribution. They can send out stuff out the back door and we have nothing to say about it.
Yes and no. We can limit parking or we can limit loading spaces, things of that nature, not specifically limit distribution. But yes, under a limited brewery license, I'll read it to you. The holder of this license shall be entitled to brew any malt alcoholic beverages in a quantity to be expressed in said license, blah, 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 depending on the fees, not in excess of 300,000 barrels of 31 fluid gallons capacity per year, and to sell and distribute this product to wholesalers and retailers licensed in accordance with this chapter, and to sell and distribute without the state, blah, 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 and to maintain a warehouse.
And that's what Bull and Bear has. That's what Bull and Bear has now.
Yes.
So,
but their shop is not big enough by the nature of the square footage. They're not going to be able to make that much beer. There's no way in 2,000 feet, they're not making 31,000 gallons or barrels or what, 300,000. They're not. Untied is.
Yeah.
That's more in line with an Untied.
I think the challenge though is that the model for these breweries is a level of distribution. I think what we're trying to avoid is the level of distribution within the downtown. I don't think you just make money on the people that come in and buy your beer in the store. I think part of the business model is you are getting your brand awareness there, but you're also selling it elsewhere. It's just you want to limit how big it gets where you're now selling to all these other places.
It depends.
Distribution also, yeah, a distribution,
Limited
warehousing
distribution.
also, yes, warehousing also is defined by what you have in stock in your inventory there. That's part of their warehousing, right? It's not warehousing meaning I'm making, thousands of bottles and sticking them in the back room and hoping I sell them. It's I'm making some beer for consumption on premises, whether it's kegs going into the bar or it's some growlers or stuff in a refrigerator that I'm selling to people. And distribution, and I could be wrong, but distribution also is people walking in the premises and taking it out with them, people buying growlers and taking it out with them. The definite distribution is, there's different definitions of distribution in terms of, am I trying to get into Gary's Wine and Marketplace? Am I trying to get to Total Wine and Marketplace? You're not making enough beer in a 2,000 foot capacity production. Total Wine and Marketplace is not selling you beer because you can't make enough for them to put it on their store shelf.
So we do have to
It's not
limit
happening.
the size of this space. We can't let it just grow to any space, because if we
Yeah.
did that, we'd be in a distribution business. So the
Exactly. But
4,000
Jennifer's
square
point,
feet has to be-
Jennifer's point was very, very good. We don't really want to limit the seating size of it, because would we object if somebody said, I'll only have 3,000 feet of production, but I think I can make enough money with another 5 of seating? Because a restaurant could come in and say, I could seat 5,000, sit tables at 5,000 square feet. We wouldn't turn them away.
So the proposal on the table then is basically saying that you can have one of these brew pubs or these breweries in town, but your production facility can be no longer larger than 2,000 feet, period.
Or 3,000.
No,
I mean, well, but Krista just said that the Bull and Bear is pushing 2,800. Did you say
Yeah,
like
right, that's about
2,800 feet?
Yeah,
That's, I would limit it to 3,000 feet and see what happens.
Okay, so
Because if this,
then we get into Rich Fiore's question of, is that the right number? Is it 2,000, 3,000? Bull and Bear, I don't know what capacity they're gonna have to distribute. I don't know how much they can produce in the 3,000 square feet or 2,800 square feet.
And even if they put 2 chairs in the front window and the rest of it is all production, I mean, where is the downtown feel of meeting the 3,000, but having 2 chairs in front?
Right. Part of it has to have the interest in the front. Like Krista was saying, you have to have the seating on the storefront area in the front, even and especially on a corner, you have to have that activity at the street front.
So some percentage, maybe it has to be 50% of the store or 25%, or we just let it float?
I would limit
That
it
was
to
the point of, that was
production.
Krista's point about the seating, is that it inherently dictates the other, the production. piece.
No, but Matt, you're kind of,
That was-
if they're limited to production of 3,000 feet and they put 2 tables, they can't make any more. They don't have any more fermenters. They don't have it. They don't have the capacity to put more barley. We're not allowing them to put more refrigerators. We're not allowing them to warehouse it. Production is defined as the making of the beer. And if they choose to put 2 tables, they're going to go out of business, because they're not going to be a brew pub. People are going to walk in there with their food, whether it's a pizza, whether it's they go to a local restaurant and bring their dinner there. If they don't have a place to sit and hang out, they're going to go out of business. So if you limit them to 3,000 feet of production, making of beer, that's all they can do. They can't distribute more than they can make.
If we go back to the 4,000 square feet that we mentally thought of before, just throwing that number out, and 3,000 was production, that means that 25% of the total area is going to have to be tasting or seating.
Yes, and I think, but Jennifer's point was very well taken. I don't think we want to put a limit on the tasting area, because if there's big,
to say you have to have at least.
Yes, I agree with that. Definitely. You have to have a minimum of, but not a maximum, because
There
to
you go.
Jennifer's point, if Winberry's goes out of business, or some of the bigger restaurants, what if West Elm goes out of business? Then, well, now if somebody thinks they can make enough beer in 3,000 feet in the basement and fill the entire upper floor of West Elm, we should not discourage that, because we have to think.
Square feet of production area and 1,000 square feet or more of seating. Something
Yes,
like
that is a very good way to do it. Have a minimum of seating area, but not limit the maximum seating area.
Okay, so how do we all feel about that?
I feel
Good.
good.
Everybody say yes. Tom Behrens, you got to write that up.
I'm taking notes,
You and
yes.
Krista can write that up.
I think we have a handle on it.
That's the CBD.
Yeah.
We have to distinguish this between the CBD and the light industrial, because if an untied comes to us at 10 or 15,000 feet,
They can produce.
and they're in a light industrial, I don't think we want to discourage that.
So let's say for right now, just to sort of pause for a second, for right now, we have the CRBD defined, and that's the one that we were most concerned about, right, Krista? Because these are uses allowed in the CRBD, and breweries weren't really properly controlled or properly defined. If we define it this way, 4,000 plus a minimum of 3,000 distribution, 3,000 production, 1,000 minimum seating, we've got the CRBD covered. Now, in the LI zone, it's not allowed at all. It's not a permitted use, not a conditional use. You have to come and get approval for it. Is that
Oh,
right?
it is a permitted use. And
It is.
Yeah.
Okay, so it's permitted use. Do we have to do anything beyond, picking up on Andy's point? Is it already done? Is there anything we need to do to the LI zone? Or
outdoor
can
seating?
they just come there and do it anyway?
They could with, find X lot and do the conversion and,
Do we really need to do anything there? I guess?
Well, do we want to permit outdoor seating? Those are the only concerns. Because like Krista said, if there's a 10,000 or 15,000 foot building available, they'll base it on their business plan. And
then if that was the case and we had a 15,000 foot building and a brewery came, what would, to apply for that, how would that work? Is it automatically approved by, Gary, or does it go through planning and zoning, or does it go through, what am I trying to say? Not planning and zoning, but through, zoning board, I meant to say, goes through planning board or zoning board.
There are two things to, I think, keep in mind about the LI zone. Number one, as opposed to the central retail business district, they do have to provide on-site parking, and they're really virtually hardly any of them going to be able to provide much parking. Some of them have parking in the back. The other thing is that we don't even have a parking standard that we put in the ordinance for this use. So we have this chart of all these various uses, and we started thinking about the breweries in the CRBD and really didn't think much about them in the LI. We could either remove it from the LI for now and think about adding it in later, or think about what the parking ratio needs to be in the LI, because if you have more production, that's fine. You're going to have limited staff. But if you have a corollary, you have to have some tasting area by the law, then you're going to have cars parked for longer periods of time on Chatham Road. And
what we're saying is that if they came in and they put a facility in, we have no way to require them to do parking.
Well, they would have to get site plan approval too.
Well, we do, but if they convert an existing building, there's nothing that says that triggers a site plan. It only triggers a site plan if you change
Make
it
an amendment.
to a use that has a higher parking requirement, but you can't point to what the parking requirement is for that use.
Yeah, and a lot of people are taking Uber to these places if they're gonna hang out and do stuff. They're not, that's the other consideration. It's not like the dentist and you have to have one per, 10 for every whatever, so you
So what
have.
if we just ignored it in the LI zone? What if we just ignored it for
Yeah,
now?
I think if
Didn't
it's
address it.
I think if it's as of right and they've got to come for plans or whatever, I don't think we put any restrictions on it and we let the business model dictate it. And if it works like Untied, we should be happy because we don't have a vacant building and we have revenue in the town and we leave it. But I think that's a good suggestion. I think the CRBD we've covered and we leave the light industrial to what it is.
I think that makes sense. All right, good. All right, we'll do that. Okay, so let's go to, Jay is going to give us Jay and Krista and are going to talk, maybe Amanda too, going to talk a little bit about the ORC 1 in the R10.
The only thing I want to say is we discussed last time converting the entire ORC1 to R10. Seems to me that the two properties to the east of the St. John's, the church, really one of them is currently an office building. That neighborhood, if I can call it that, and it's really dictated by the big hotel across the street. The ORC applies, in my opinion, to those. I certainly think, as everyone else I'm pretty sure agrees, that the residential properties beyond St. John's to the running down Springfield Avenue to the west, R10 is appropriate. I don't feel strongly about it, but I just spent a little bit of time thinking about it and looking at it, and that there is a distinction in my mind between the couple of properties. One is currently an office building, as you know, the real estate office. The other is still residential. I think with they satisfy and were the intent of what was done whenever the ORC was set up. Seems to me that should still apply to those, and we should make the change only for the properties, the residential properties beyond St. John's. Just a suggestion.
But what about the
difference
church?
from what we talked about last time?
Jay, what about the church? I'm sorry, did I miss that? What about
Yeah,
the church?
doesn't. I mean, the church doesn't fit into either one. It's an
But
outlier.
Jennifer's question was, is if the church leaves?
Yeah, I think it's still the appropriate use at that spot. I think the zone was set up because those were residential properties, and the goal was to maintain them in their historic character. I think that was the intent. There'd be no other reason to do it. That clearly, it doesn't apply to the church.
Residential character, that's what it is.
Right, but didn't you ask if the church left and the developer bought it and said, I'm going to put 5 big residential, it's a big property. I'm just asking the question. It's a big property.
It's a big property. The church isn't going in. Let's start with the notion. The church isn't going anywhere. Of course it could, but it's a big property. But remember, it's still, if we want to limit the usable area of that, fine. I mean, I don't have, the FAR doesn't, that's fine if you really want to do that. I think it's a meaningless exercise, but we could, if that.
No,
it still
I
seems
don't
to
want to
me
do
that
anything.
I think that's a better approach than zoning that R10.
So if we could say there's 2 alternatives on the table, well, maybe 3, but one alternative is leave it the same. The other alternative is take everything R10. The third alternative is you have 3 that are in the ORC 1, starting with the church and going east to 2 buildings. The fourth alternative is the church is R10 going west, and you have 2 sites to the east of the church that are ORC. So if we look at the third and fourth alternative, the question I have for Tom that we talked about with Steve Warner and Amanda a little bit earlier, and Jay, is we have a spot zoning situation if we just have 2 lots that are ORC, or even if we have 3 lots, including the church and the 2 buildings are ORC. That's just a sort of planner technical question that Steve wanted to defer to you, Tom.
Well, I just want to throw one thing in for your background information. I don't know if it's going to make any difference to anybody, but back before the ordinance was adopted in December of '03, when the ORC 1 zone was created as that knee-jerky kind of reaction to the one situation, the whole strip was an MF zone, multifamily.
Oh, wow.
Wow. That,
Oh,
that would have changed the whole look of that block.
Oh, absolutely. Yeah,
Yeah.
dramatically.
I like Jay's idea. I think Jay's idea is good, my personal opinion.
So how does the board feel about the church either in ORC or the church in R10, or does anybody care?
Well, right now, the church is a conditional use in R10 and it meets all the conditions. It has the lot width, it has the 2-acre minimum. I don't have an ordinance in front of me to look at and see if it's also a conditional use in the ORC 1 zone.
Oh,
If it was, it would have the same conditions as if it was in the R10 zone. So I don't think putting it in either one or the other is gonna have any kind of impact on the church as long as it's a church. The question is, if it does not a church, then what?
Jennifer?
I think I like 4 just because the office residential character, if for someday when the church goes, it's not residential character that you can put an office in. So how would anybody know how to develop it if it's ORC zone or ORC and R10? You know, if it has the ORC, it's confusing, is what I'm saying.
And if it has the ORC, the FAR is 40% as opposed to 25% if it's in the R.
But you could subdivide and make some nice, you know, a nice development out of it as R10.
At 25% instead of 40%.
So that's kind of interesting.
Makes sense.
Yeah. So,
Krista do? What, Krista, you wanted to make all 3 of those multifamily, right?
My suggestion previously was to do the church and everything to the west of it R10. The other 2, I threw out MF because I suppose that that's something that is likely to happen. And then I did, of course, wonder if those 2 lots, putting that in a multifamily zone, if that was not really spot zoning because you're surrounded by MF, so that probably would make sense. By the
but
same.
you're not surrounded by MF. You've got the hospital, the hotel across the street.
Next to it,
Around the.
and all the way around.
Well, that's on a different street. Okay.
Well,
so Tom, on this question of spot zoning, whether we have the church in ORC or just 2 sites in ORC, how does it work?
Technically, I think we brought up the issue last time that because they're already within the existing ORC, that if you were to leave 2, it probably would not be an issue. I think including the church, because of 1, its size, and also adding a 3rd lot probably makes it a little bit stronger if there was any contention. But I think there's there's a rationale for the zoning. So even if it ended up being 2 lots, there would seem to be a case to be made that it.
I think what Jay's pointing out is that those 2 buildings are very similar to what's going on in downtown in the original ORC, kind of a similar feeling.
Yeah.
Putting words in your mouth, Jay, but to me, that's kind of the way I feel. It's more appropriate. As soon as you hit the lot with the church, everything changes. So the thing that I like about R10 on the church is that it's the 25% FAR. I don't know whether the board feels the same way or not.
I agree.
Yeah, sure.
I think the ORC feels right, and I think the 2 people who own those 2 properties would prefer not to be downzoned to R10, and it seems a little bit like you're, affecting their economics a little bit by doing that. So, and then Krista was saying maybe multifamily. I think if I had to express a preference, I would do R10 from including the church west and keep the 2 buildings in ORC. But I don't know if the rest of the board feels the same way or not. It's up to you guys. Unless Jay, if there's anything else.
No, I agree with that. That works for me.
Yeah, that's good.
Okay.
Then Steve, does that mean that we can make that change in this go round? Or you think that we need to do some kind of a master plan reexamination report? Or what's the right legal step to take so that it's not subject to a challenge?
Well, again, first of all, of course, we're just making the recommendation to the governing body, assuming the governing body adheres or follows that recommendation. If they introduce it, it comes back to us for master plan consistency review. They then notice for a public hearing on second read, and whether we leave it with just any change we make to that zone, we're changing the boundaries of the zone, any of these options. All that does is require the governing body, when they do their 10-day notice for their second reading public hearing, to do what's called the section 62.1 notice and have a notice 200 feet, a 200-foot perimeter around the current boundary that is being changed. That's what's required regardless. So if you do that with a master plan reexamination associated with it, you don't have to do that broader notice. If you don't do it with a master plan reexamination associated with it, you do have to do it with that broader notice. In my opinion, that shouldn't dictate what you decide from a policy perspective. And again, whether, even if we don't do a master plan reexamination, it's probably not going to be an oppressive additional notice obligation on the city.
So, Councilperson Little, do you have any thoughts as to whether, as I understand what you're saying here is that in addition to putting this on the agenda for a second read, there's additional burden to notice everybody specifically within the 200-foot radius of the zone that this is happening.
And any of these options, that
They
would
can
be.
come to the council chamber and have conversations. I think what we're proposing will be very welcome to the property owners, personally, but they would have the right to come. I know that the people across the street who have been so concerned about 603 Springfield Avenue over the years would be very happy with it. But I just wanted to see if that additional notice created any burden, for you that was problematic.
I don't know the answer to that question, but I can reach out to the city clerk and the council president tomorrow and see if they have any thoughts about that.
Mr. Chairman, if I might.
Yeah.
597 Springfield, which is the first lot to the west of the church, is an office building. It's a therapist's and such. So we're not concerned about downgrading or down zoning that house, but we.
Oh, that's a good point. I thought it was residential.
No, it's a therapist's office. Multiple people work there. And I'm not sure about the one between it and 603.
Yeah, two of those lots are residential and one is 603 and the other one is the therapist's office.
Well, that changes the dynamic a little, huh?
Well,
But it's right next to the church. We can just keep it in the ORC1.
Yeah, but we were just saying we weren't going to keep the church in the ORC, I thought.
well, it's an existing,
Right.
pre-existing legal non-conforming use.
Yes.
They can be there forever. Their problem would be if they wanted to expand it, they would need a use variance if it becomes in the R10 zone, but it does look like a house. So when they leave, they may just sell it and somebody, either has the same use or somebody converts it back to a single.
And if they wanted to expand it, could we put a restriction on it that they have to expand it to keep it to look like a house
Well, that's
so
kind
that
of
it doesn't turn to an office building? The back isn't built into an office.
That's
What's that,
purpose.
Jennifer?
Yeah.
That was what was supposed to happen before.
That was how ORC works. Yeah. But it didn't work.
Didn't work. Well, that thing also changed hands 1,000 times.
Much bigger than they intended.
So the point you raised, John, is a good one because it's a similar issue, as we said, to the east of the church. You know, we don't want to hurt them economically. On the other hand, we kind of like the idea of the R10, and that seems consistent. So you've got like a 50-50 mix there. Half is ORC and half would like to be resident or is residential. That's interesting, huh?
And we got a lot of feedback to that effect that during the master plan, that neighborhood wanted to be residential. Not
Right.
just, I mean, during that application, like you said, Bill, but also during the master planning. They kept
Yes.
saying, why did this happen? We're residential, you know, I
Yeah.
don't understand. So that's why it was one of the first things on our list to fix.
I think it should be residential.
I agree. I think it's pure
All right,
intent.
so we're going to be consistently inconsistent because we think it's the right thing to do, and I'm okay with that. So we're saying from the church to the west is R10, from the church to the east is ORC1.
Just stays where it as is.
Yeah.
And the church itself is going to be
R10.
R10.
Okay.
Okay.
All right. Well, we'll blame it all on Beth. Okay, Tom. Write it up, Tom.
Got the notes, yep.
Write it up. Okay. So here's-
You wrote the part that it's my fault too, right?
Yes.
Yes.
I highlighted it.
She said we could do it. So,
603 is going ahead though, right? I saw fencing
yes.
one.
Yeah, it is. I mean, it looks like they've got construction fencing around it, so, and they've been in there.
Finally gonna happen then. All right.
They've been in there, working out the architectural embellishments inside. So here's what I'd like to do. I'd like to have Tom and Krista finish drafting the two things for the brewery and the ORC R10 for it to come back to the subcommittee. And with the board's approval, assuming the subcommittee is okay with it, we will then ship it off to council as we discussed before, rather than dragging the fine print back to the board level. We'll just bring it through the subcommittee level. And that would be Beth and Jay and myself, of course, Tom and Krista. And then if you'll deputize us to approve the drafting for the brewery and the drafting for the R10 ORC1, then we can conclude tonight and we will have passed it on to council. Everybody okay with that?
Jen has a comment. You good?
Yeah, I'm good. I just have a question.
Okay.
I'm totally okay with that plan. My only question, I just want to confirm with Tom that the parking garage structures, I know you were going to rewrite it because it had several references except in other zones.
Yeah.
I just want to be clear that we confirmed that we're just having parking decks in G2, G1, RO60, P1, Prod 2, Prod, and light industrial.
Correct, as listed in that paragraph.
Like by accident, oh, we're going to put it here in the B zone, or we're going to put it over there, right?
Correct.
Okay, just want to make sure.
Thanks, Jennifer. Thanks for following up. Andy?
Bill, I just have two very quick things. I know it's late. One is a question, and it just relates to tonight. We always start with the engineering. And I think if we start with the architectural, if we had seen those and the public had seen the architectural drawings of what the property, the building is going to look like first, all the questions on the wall and all of that stuff, would have seen it in perspective. It's hard for a lot of people to understand the dry engineering of we're raising the space 7 feet and I'm putting a 14-foot. To me, when I saw the 14-foot wall without having seen the architecturals, I was like, this looks like a tunnel. I've been in real estate a long time. We've always done the architectural first so that people get a feel of what the property is going to look like. And then you delve into the engineering in terms of grading and all of that. So I think my personal opinion is it would have, the 70 odd people watching would have had a much better feel of what this property would have looked like before we did the engineering.
That's a good point. I guess, Mr. Warner, I guess it's up to the council representing the applicant as how he wants to proceed. But it's certainly, in this case, Mr. Klein, first of all, could have cut his presentation by 3/4, and he could have said kind of a few times less. And then we would have been a lot better shape than we are today. But
But can't we dictate that and say we would like to see there were
I think it's
10
a good
renderings.
idea, but Mr. Warner can answer that.
Sure. Sure. Technically, can you dictate it? No, the applicant is allowed to present their case the way they wish to do so. Effectively, can you dictate it? Certainly,
We can
because
suggest
you're guarding the hen house.
Yeah.
So when you, or for that
yeah.
matter, when you deputize me to let applicants counsel know that they'd be well served to start with the architect as opposed to the engineer, you've done it.
Pictures
Yeah.
worth 1,000 words. I think.
Yeah, and half the questions were, they just, people, first of all, forgetting notices or whatever, and it's all on the website. You know, nobody's really doing that. They're freaking out that something's being built in their neighborhood. But when you show it to them, at least now they got a concept. Okay, that's my one question. My second question is 83 Maple. We still don't know what ordinance. Are we going to show up at this meeting and have them try and tell us what ordinance they think they're doing? And then are we as a board going to vote on that? Are we going to be put, I just don't want to, on September 23rd, are we going to be put on a spot to have to vote as to what ordinance we're looking at their application on?
All right.
Because as of the last meeting, we have no clue.
Mr. Warner.
My understanding is that I'm virtually certain if they come back and proceed with an application, there will be an agreed upon ordinance between the applicant and the objector. I expect that to happen. I don't.
The
expect
objector
you to
meaning
be-
the attorney? Okay.
Yeah, the applicant, and the objectors can, yes. And by the way, if I'm wrong, I am even more certain that that I will be able to advise you without making the decision for you legally which ordinance it must be, as opposed to which ordinance it must not be. So,
Okay. Because, well, and one of the
Why didn't
reasons
we
why
do
I'm
that last
asking-
week?
well, we're not quite there yet, but we might be now.
Reasons also why I'm asking this, because I don't think any of us want to be put on the spot. And I think Jay made a very good point at the last meeting. I'm not comfortable voting on this when he said that, and I don't think anybody was. But more importantly, I was a little bit concerned with Mr. Weber's comment of, you know, when we submitted the application, the person didn't ask the question, so the board de facto waived the ordinance. I've never heard of that in my life. My father's a real estate professor, and I've asked some other attorneys. I don't think the board waives anything because somebody accepting an application doesn't ask a question. Am I wrong on that?
Well, again, two things. One, we're talking in general and in hypotheticals. We're not talking about a matter that's pending before the board specifically.
Right.
Number two, you don't waive your right. I think at best, you know, if you, by not asking a question, look, I think in that hypothetical, I think what we were being told was, you didn't ask, so we didn't tell you what we didn't want to tell you. Well, no, and under those circumstances, you never waive anything. The only possible situation is what's called estoppel. If you make a determination knowingly, and then later on you could be, or if a long period of time goes by, then you might be deemed to have, by virtue of estoppel, a preclusionary principle, have waived your right to make a different determination. But under those circumstances, short answer, absolutely not.
Based on that answer, I would love someone to make a motion to adjourn the meeting.
So moved.
In a second.
Second.
All right. Thank you all.
Have a good
very
night,
much
guys.
Tonight for staying up so late, and we'll see you on the 23rd.
All right.
Thanks.
Good night, everyone. Thank
Good
you.
night.
Take
Be
care.
well, everyone.
What about the?
Steve. So what are we doing with that resolution effectively?
Oh, it's next. What I understood from the chair was that we're. I'm sorry, Mr. Chairman. You wanted to do the resolution next meeting or tonight?
No, yeah, I guess I had forgotten about the resolution. Is that something the board has to approve, or is that just something that's a letter that's sent off to off to council?
Well, we could do it by letter. If the board's decision this evening was to make the recommendation to the governing body now and to deputize others to fill in the blanks on the brewery, and on the ORC zone.
That's what I heard.
Then if that was the decision, we will convert our resolution to a letter that can, be forwarded to the governing body along with the attached.
And then it
Either
comes-
way is fine to do it. I was under the impression that some were selecting resolution over letter, but at this point, the
I think
resolution
we were using
technically.
the two terms interchangeably in my mind.
Yeah.
One or the other. In other words, let's get it to the council some way, and then it comes back to us, obviously, for approval as master plan. And then I guess we
Right.
put a resolution together at that point. Is that right? And it goes off to council. at
Well,
point?
yes, yeah, normally it's just a letter to forward it to the governing body as a recommendation. I thought I was hearing from some people that maybe they would prefer a resolution. There's nothing wrong with doing it that way. But certainly we can't do it now for tonight because we lost the voters
Right, yeah,
on that resolution. So we have to morph back into the more informal mechanism of a
And
letter.
I think that's what we intended anyway. I don't think anyone was hung
Perfect.
up on the word resolution.
Okay, perfect.
All right.
All
All right.
I think you get-
Thanks, everybody.
All right.
Thank you all very much. Krista, thank you so much. And Chris too, and Matt. I mean, you guys really, that's a lot of work. So thanks. And Amanda and Steve, thank you for the hard work and, the patience. And I'm going to call Mr. Klein and coach him a little bit.